So there is seating up here in front, if in case anyone wants to move up in front. Uh, when we started thinking about this discussion, uh, we really wanted to do something on the telecom bill, given how vast the scope of the bill is. But one of the things that we wanted to do was a physical discussion, because we haven't done that for a few years, and I think some of you might be new to this format, but it's a participatory format, which means that there is no panel. You are the panel. And so you can ask questions, you can give answers, you can contradict. The basic idea is, please be respectful and please have talk about stuff that's meaningful. If you have a point of view that will add value to everyone else in the room, that's how sort of we try and do things. And we started right in the beginning when we started doing discussions. We started with this format because we wanted to try something new. And even then, when we started having panels, we sort of put 3 or 4 people on a panel, but 60% of the time was for having conversations with everyone here. Uh, so the way we look at it is, everyone here is smart, everyone here has hopefully read the reading list and done homework and come. And all of you would have a point of view. So the idea is to learn from each other, ask questions about what you do. I have questions, right? I've got like 70, 80 questions that I've thought of. Many of you submitted great questions, so we'll pick those up. But we also want answers from all of you. What do you think about the bill? So we're going to segment this in various parts. We'll probably start off with the trickiest part of it, which is, or probably the easiest part of it, which is definitions. We'll cover licensing, we'll cover KYC. Uh, the overall objective for us is to help you do a filing. We want you to participate in the consultation. We want you to take notes from the conversation that we're having here and participate in this, because that's democracy, right? It's on us to not just vote but also participate in the government process and hope that someone listens to us and maybe the bill improves. We will have differing views, but that's democracy. So, this. So just a few ground rules. Just wait for your turn. Sometimes what happens is there are lots of hands up, and I might forget to come to someone. So please, once someone else has stopped speaking, please put your hand up again and I'll come. It may not be in sequential order. This is a bit of a mess. That's how it works, but it's fun. So enjoy that. Um, I'm going to start with a few comments that I had sort of noted down about how I think about it. And I go back to the net neutrality conversation that we had some, what now, how long has it been, the past 7 years? It feels like an eon, right? So, uh, it and one of the things that I used to say a lot that time was that the word OTT is a telecom creation, because we're talking about the internet here. And access service providers are access service providers. And we're going back to a debate all over again that we thought was already settled, but that's the nature of the regulatory beast, that sometimes old ideas come out, and when there's an intent to change things, I know Vikram might not necessarily agree with this concept, but I'd love to hear your disagreements, Vikram. Um, and so our purpose here is to basically go back into some of those debates, so that in case you weren't following the net neutrality conversations or the TRAI OTT conversations that followed, let's go back to some of those debates, because there's some folks who might need their thoughts clarified on that. Same service, same rules is an argument that keeps coming up, still keeps coming up, never stops coming up, but it, we deal with it. And so, and there are new questions, new perspectives that we may not have thought of, might not be in this list of ideas. So please bring those up as well. Uh, I'd like to thank Meta, Google, Disney Star, ISOC for the support for this conversation, to CCG at NLU Delhi, CIS India, and CCOAI as our community partners. Uh, I'm going to, in fact, is Neeti here from ISOC? Hi Neeti, you just walked in. Great. So I'm going to put you in the spotlight straight away. Uh, take a seat anywhere. So I'm going to put you in the spotlight straight away, right? So you wanted to talk a little bit in the conversation that we had earlier about uh, the definitions uh, of telecommunication services. Uh, what is a telecommunication service?
So I think in my mind, hi, I'm Neeti, by the way, I work with the Internet Society. In my mind, of course, like if you think about it in a very semantic manner, a telecommunication service is anything that enables someone to communicate with another person or a group of people, right? But in the way that in India, how we define a telecommunication service is quite different from how we'd say provide services of this nature over an OTT platform. When I say an OTT platform, I mean over-the-top service that anyone can access without permission, without the need to identify yourself, and without providing any form of government identification. So what it essentially does is provide a level of privacy, anonymity, that anyone can afford and anyone can access. Whereas I feel like the way that we've been defining telecommunication services in the country for so long, your voice services, your text services, they essentially are quite different from when we consider services like say WhatsApp or Signal or any service that allow a very rich interactive environment, such as your ability to be able to exchange images or videos or any sort of rich interactive service. So that in a nutshell I think is the difference between like semantic and definitional, like legal definitional distinctions in the two.
Vikram, would you agree with that definition of like with the differentia between telecommunication services? Sorry, you're going to be in the spot a lot today. Don't worry about it. Uh, Arjun.
So I'm here to listen more than to share my thoughts because we are still, kind of digesting this whole draft, right?
So, at a
The-
personally, what do you
I know,
think?
I'll be a little cautious because it's an open platform and I don't want Twitterati going around that Vikram said this and Vikram said that, right?
Okay,
So I have, constraints of that nature.
this is not Chatham House.
Uh, yeah, so, but yes, I'm here to hear more. And one can always share some general things in the sense if some of you talk about the mama companies. Oh, I'm surprised you haven't heard this term. So, mama is the new term which replaces FANG.
Oh, really? Okay,
Yeah.
I haven't heard this one. Okay, what about the
So,
mama companies?
MAMAA is the new term, right?
Okay,
Maybe
so
you can look it up quickly. It's, it's got all the internet companies as part of the group, right?
looks like 5 out of billions, but
No,
sure.
so it's Meta, Amazon, Microsoft, Apple, and Alphabet.
And
Alphabet.
Alphabet, yes.
So
Okay.
that's the new term.
So how do you see? Do you see a difference between them and regular telecom providers?
No, in the sense that communication services of all sorts. So the thing is that there's been kind of new developments. The whole digital space by itself is a new space, and I think globally all regulators and all let's countries are trying to grasp as to how to manage this space.
Hmm.
So yes, I think globally one will be seeing like EU is doing some work, and there are many countries trying to understand how to manage this space because, as is the norm, is that technology or innovation outpaces regulation. So how do you address that gap or how do you manage that is the issue. Yeah.
So how do you manage that gap?
Working on it. That's what we do at CUI. Continuously, you've got to work on trying to address the new requirements as they emerge, in matching the technology and the regulatory piece, so that there is a good market environment, right? And innovation has to thrive. And how does society at large benefit from the facilities that are being created?
Hmm.
So, I mean, there are big societal implications of how do you manage this whole space. Thank
Okay.
you.
Apart, it looks like you want to comment on something. Anyone else
I
want to
just
comment on
wanted to-
definitions? I'll come to you.
Yeah, I just wanted to prompt thought also on the preamble, which does play a role in the interpretation of the statute given that telecommunications law is fairly litigious by its very nature. So the preamble, if you read it as well, does not have any reference to certain constitutional doctrines which have emerged in the context of telecommunications litigation, public law doctrines, such as diversity of media and voices, such as freedom of speech and expression. Because when you read it, it says, considering telecommunication is a key driver economic and social development. And this becomes relevant and important, and I think more people may look it up now, because when there's an ambiguity in a word, whether in a specific clause, subclause, or within the definition by itself, this does serve as an internal statutory guide of construction. So Nikhil, I think that may also be important, that a lot of the work which has gone either in courts or before the TRAI may also be better reflected in the preambular text itself as people look towards sending comments.
So, how does that impact the definition of telecommunications?
So, for instance, if there is a, so let's go to the definition of telecommunication services. It's in clause 21, which says telecommunication services means a service of any description, in brackets, including broadcasting services, electronic mail, voicemail, voice, video, and data communication services, audio deck services. It goes on. It's a laundry list. It's not based on certain criteria. It's based on definition of function or things we already use and utilize. And I think you're focusing greater energy on over-the-top communication services.
No, I don't know what data communication services are.
Yeah, so the preamble may inform it, in addition to the other materials which have been published when this passes into law. So that's why I'm saying the preamble may serve a purpose. For instance, when we say over-the-top communication services by itself, right? And there is an exercise of regulatory power pursuant to the interpretation of the clause. If there's an ambiguity there, whether it falls within it or does not fall within or outside it, and then goes towards the exercise of power, which is under specific clauses, the preamble plays a role there. And we can see that in litigation through the years. So that was a limited point I was making, because we are proceeding to definitions, but there is some text above that. There's some text above the short title as well. And that text is important. And we may remember that when we analyzed, for instance, the Justice Sri Krishna draft, which we criticized for having the wrong objectives in the data protection bill. So what are the objectives of the law also need to be based on public law doctrines which have come through constitutional litigation, which are free expression, the trusteeship doctrine, in which there's no exclusive monopoly over the telegraph by the central government, but it's a custodian of the airwaves. Conceptual shifts which have happened post-independence due to the constitution.
So here there is a shift in terms of the government gets exclusive monopoly over a host of
I
services,
think they have not
right?
spelt it out well enough. They are saying economic and social development. They do mention access at a later point in time. But there are further objectives. Telecom is not a driver just of economic growth or social progress. It's also a realization of rights to receive information, to broadcast it, which should meaningfully be reflected in the preamble for every Indian. And I think that is a core objective which should be recognized. That's my opinion.
Yeah, actually, before I went into the other thing, I wanted to sort of ask Apar, would that not sort of bring in a more content-based perspective? And that would be worrisome for me to have that kind of a discussion in something that's core infrastructure related. So introducing those values, which are extremely important, but I feel that the moment you introduce that, it might risk it becoming a content-oriented discussion, and we can already see that risk sort of percolating with the inclusion of OTT. So one of the things that I wanted to sort of also build off what Mr. Tewatia was talking about earlier, the EU and other jurisdictions that I've talked about. From what I've seen in other jurisdictions, there's also a lot more nuance that has been brought into the definition of OTTs that they want to include within this sort of category, and number-based information communication services and those kind of things. So that is completely missing from this debate. And the other sort of extension that goes into is, why did this happen in the first place? There are two potential arguments. One is the older argument of the whole level playing field that you wanted to, telecom versus OTT sort of this thing. But the other is more of what is talked about in the explanatory note that, we are introducing KYC and all of that for preventing cyber fraud. So that is a target specifically at the OTT from my perspective. And if that is the objective, then what we need to really look at is the efficacy of first KYC itself, two, and the threat that KYCs bring when you...
So we'll get to KYC later. I am just looking at definitions here, and there are, for example, there's no clear definition of what are communication services, for example. And then when you expand it, there's no definition of what are data communication services. Data communication services are pretty much what on the internet is not a data communication service, is my question. Mr.
Sure. I think it might be worth actually reminding ourselves about the regulatory relevance of this definition. And I do believe that in that sense, this definition is extremely unhelpful. It's too generic. And if you look at the definitions that you would expect from other utility regulation, for example, electricity is never defined so trivially as to include, a battery that you might be using at home.
Transfer photons from one place to the other,
right.
because then you'll regulate light.
You don't say transport is the movement of things, right? Because that's what it actually is accurately. But clearly, in regulatory terms, it's trivial. And I think this is, to me, the biggest challenge of this definition. It's trying to be too clever by half. It's including everything, and whatever is missing, they will be very happy to add. But I think in regulatory terms, it's rather irrelevant, and that, to us, must be a concern.
Anyone else have a take on the definitions part or any questions around it?
Yeah. Supplementing the points which have been already told by Sir and Sir. So when we talk about the definition, so Sir talked about telecommunication infrastructure and services, but if you specifically see the section 2 subclause 17, which talks about telecommunication, it supplements by saying any other, or say other electromagnetic system. So it starts with emission or reception of any messages by wire, radio, optical, or other electromagnetic system. Now that would say, as what we were discussing about any protons and neutrons in the wire. It is, I believe this is exactly the same definition. Wherever the communication is happening on any electromagnetic system, that will be covered under the definition of telecommunications. And that is what a worrying part. Be it over WhatsApp or any social media, or over phone, or over anywhere, that will be covered under the provision, and that's a worrisome for me.
Sneha, you're the one who raised the question about data communication services, etc. Right? What are your concerns regarding the definitions?
So I just have always wondered, as Sir said, that communication service by itself is not defined. If you look at the copyright law, which defines communication to the public, that is, if you look at that definition and then you look at communication services, then we're talking about, in terms of a technology which is transporting data from one end to the other. Now, if you look at that, video communication services, even OTTs would fall within the scope of that. And that's what my concern was, because are we then saying that every streaming platform is also going to be covered by this definition, which means that we're not going to be able to have any, again, an overlap between...
But it is, right? Because even video is there.
That's what I'm saying.
So not just video, but broadcasting is also there. So
broadcasting, traditionally, if you look at the way broadcasting was brought within the scope of TRI, I know we represented one of our clients in this fight about how, in our view, broadcasting services, the way it has been defined, was only carriage and not content. But that is the biggest difficulty that I have, the scope creep because of getting into content, though there has to be only carriage. In my view, telecommunication only has to be infrastructure, or communication services only has to be infrastructure, not regulating content. But the way it has been defined in terms of video communication services, without clarifying what communication services here means, seems to me to make out a case that probably even content streaming services would be included. Then you'll have the MIB and various other ministries fighting about who has jurisdiction, who doesn't have jurisdiction.
We have a whole section on jurisdiction.
I know. So that was,
yeah.
I mean, these are just my initial thoughts on that particular definition and why I think that it's not, I mean, it is going to raise more jurisdictional disputes because of not having communication services or what communication means defined because of what generally communication means.
So the other question, John, do you want to comment on this, on the video broadcast part? Go ahead. On the video part.
No, the definition of telecommunication.
Okay.
Yeah, I've mentioned this before. I think when you look at the definition of telecommunication services, and when you read that with 3.2a, I think the licensing, the exclusive privilege of the government, it basically brings almost all your digital services under a licensing regime. And if you look back on the Indian economy, 1991 onwards, Government of India has sort of delicensed almost all activities. And here we are sort of transitioning to a digital economy. And this bill practically brings almost all activities under a licensing regime. So that's my broad observation. I think definition of communication, I think those are a little technical and I would leave it to people like Sneha to comment on that.
They haven't left anything out of the ambit of the definition
you're
of telecommunications, right?
trying to bring everything in today's digital economy under a licensing regime.
I mean, email used to be, I mean, in some previous versions, email was there, audio text was there in the licenses.
Yeah.
But they've also, they've added new things like broadcast and video and data communication.
Internet-based
communications. Everything is there.
Practically your entire, I'm not too sure whether buying and selling online is within the scope. I think that's,
Even
except for digital payments, the way I understand it, except for digital payments and online buying and selling, I think it practically covers everything.
Okay, let me then ask you this. How is digital payments not a data communication?
It is a data communication, but I think the transaction part of it is something which, that service is, I think, which, I mean, it's subject to debate, yeah.
How? It's data transfer. Money is data in this case, right? With digital money. Everything is data.
So if you look at it in terms of data transfer, yes. But I think in terms of that service, the digital payment service, I think that's the only thing which I feel has been left out. Apart from that, I think everything is sort of covered in this.
So all of cloud is covered, all of...
Almost everything, yeah.
Okay.
Yeah, my name is Professor N.K. Goyal. I am known as Chairman of TMR, Telecom Equipment Association. I just barged in and listened to 2-3 speakers. Two things. Realize that the definition of 1885 has survived till date. Number two, with all experts now available to us, industry, stakeholders, legal, judiciary, Supreme Court, High Court judgments, we always hear that this is not correct, this is not clear, this is not clear. Why can't we suggest that let us do this way? Because we know the intent of the government.
What would you suggest?
I would suggest as they have given.
This definition,
Yeah,
you're fine with
as
that.
they have given. Why? Why I will tell you why. Because this is not the final thing. This is a draft. After our comment, it will be amended 2, 3, 4 times, then which has to pass to successively so many layers. So that was the only point. Why can't we suggest, okay, let us do it this way, like 1885, so it survive for next 100 years.
Anyone have ideas about how the definition should change? So wait, he had a comment. I'll come here. Sorry. And if you have ideas on how the definition should change.
Yeah, sure. Hi, I'm Roy from the Albrights Rounded group. So I think this definition, and I think as everyone has rightly said, it's really very broad, right? So I think there's limited amount of discussion. I mean, that any good discussion, quality discussion that you can have over this definition, because it looks to try and cover everything, right? So if we take that as sort of the given, then we have to go to what is the intent of the government here and what are they trying to do, right? So I think that's something that we need to think through, because I think we've also seen this kind of drafting previously, right? We've seen it in the Data Protection Bill, we've seen it in the IT Rules 2021, and what then happens? After that, it's a question of engaging with the government, trying to understand what is the intent, and then getting this narrowed down. So today, to be talking about data communication services, I mean, I look at another definition here, right? Interpersonal communication services.
What isn't?
I mean, what does that
Internet
mean,
is one
right?
is to one. So
Exactly.
anything
So
interpersonal.
I feel like, I mean, of course, we should be talking about the definitions. I just feel like nothing much. There may be some kind of academic sort of discussion
So
which
then
is worth on
question,
this.
How would you change it?
Yeah, so I think if we're coming to the question of what are we trying to regulate, right? If I take, yeah, so, yeah,
How would
so,
you change it? I
yeah,
got
no,
those
so,
other
so
points,
exactly. So my point is that if you're trying to talk about OTT communication services, right? If you're talking about WhatsApp, if you're talking about Viber, if you're talking about whatever, it may be, I don't know, other messaging services, right? You need to spell those out, right? And mention those types of communication services.
Okay, I have a different point of view, but I'll hold that for a bit. Someone here, then I'll come to you, Rahul, then I'll go to Venki.
Hi, I'm Shantanu and I work as a lawyer in the technology and telecom field. So my basic point, I mean, my discontention with this thing is that we have been, I mean, advising our clients for a very long time. Every time somebody tries to offer a...
To the point, please.
Yeah. No, essentially the point is the diversion that we see from the 1885 bill to what we've got today. I mean, it doesn't really help me explain to a client as to whether or not you're likely going to be covered or not covered by the telecom bill. So obviously
It's
we
easy, na? Everything is covered.
Right, precisely. So I mean, if
You're covered.
Yeah,
Everyone's
yeah.
covered. You're covered, everyone's covered.
Yeah,
It's
yeah,
like
yeah. So I mean,
they're playing Oprah Winfrey.
so even when we were looking at, I mean, our typical understanding was, okay, this is a Telegraph Act from the 1885, and we are trying to fit you into
How
the
would you
definition
change
of a. No, so how I would change it, at least to the extent to try to answer Sir's question to some extent, is either tie it to, I mean, once we understand what the government's trying to regulate, if of course the government's intention is that anything and everything that can be communicated is something that I want to regulate, not generally, but using this bill, using this act, this specific framework I want to apply. I mean, that's of course, I mean, we can debate whether or not that makes sense from a policy perspective, but if we're trying to look at it as a telecom bill for 2022, something that we're looking to regulate telecom services, tying it to some sort of physical infrastructure, as soon as you're getting into somebody who's being involved at the carriage level, as we call it.
All companies have servers, they have physical infrastructure.
Right. No, but I mean, in terms of how those servers are being accessed and who is providing that communication line to the end user.
Okay.
Right.
Rahul?
Sorry.
Thanks. Actually, my name is Rahul. I'm a lawyer who works in the tech field. I actually had more of a question based on what John said a little earlier. I think it makes a lot of sense that back in 1885, there were certain degrees of services which were defined as telecom services, which were regulated by the state. So I'm wondering, instead of a broad definition like this, the state has different degrees of what it needs to regulate in terms of different kind of services. So rather than one big broad definition, would it have made much more sense to have a much more narrow definition of telecom services, perhaps define other services separately and regulate them in a different way? I mean, maybe you need the lightest touch of regulation for some of them and much heavier regulation for the other. So I'm just wondering if that were to be made, would that really alter the complete structure of the bill and undermine everything? I mean, rather than one big broad definition which covers everything. I mean, now, for example, if they have regulations for telecom services, everything will get covered by it, whether or not it fits or does it make, if it makes any sense at all.
John, do you want to answer?
Okay, yeah. So I think, I mean, in terms of definition of telecom services, and given that if you look back on the Telegraph Act, or maybe the ITU preamble, which sort of sets the exclusive privilege of the government to regulate telecom services, I think telecommunication services, as far as licensing is concerned, should be restricted to the activities of those entities that have been allotted the scarce natural resource. And so I think that is at least my understanding of what the scope of telecom bill should be. Anything beyond that, to me, is I know we'll come to the jurisdiction part, but I think is something like your IT Act or the proposed Digital Act should regulate, and I think these are very different. I know there needs to be a segregation between access and services. I think this is something I saw this in Nikhil's tweet prior to this event on how that segregation has to be there.
I have a very clean separation.
Yeah.
Very clean separation. Access services which use spectrum should be regulated and licensed.
Yep.
Anything that's not access should be free for all.
Yep.
There is no rationale to license anything that is not an access service provider using a scarce resource called spectrum.
Yeah.
Separate content from carriers, that's the most natural way of regulating this. Otherwise, you'll keep mixing up industries, mixing up services. Just because telecom operators provide voice calling doesn't mean that that has to be bunged in with access services and spectrum. So charge for utilization of spectrum to consumers, which they already do, and to businesses, which they already do, because you have servers that connect. It's the same argument we had during net neutrality. Venki.
Yeah, so Venkatesh from BSA, the Software Alliance. So a couple of points. I think the concerns stem from, as everybody has pointed out, the overbroad definition, which includes all telecommunication services, the traditional ones, and more concerning for us is the software and the IT industry fully is included. So Nikhil mentioned, is cloud included? Of course, like everything is included, cloud's included. So this overbroad scope means that not only would companies have to comply to all the regulations that now DOT has, also regulations from MATI, also other laws that's come up. So that's one concern. The second concern is the central government still retains right to define new services. Now, there are no guardrails as such, but at the end of that clause, if you see the definition of telecommunication services, says future services can also be included. So the concerns are overbroad definitions in all three terms: telecommunications, telecommunication networks, and telecommunication services. All three have to be changed. You can't change one, and all three flow from the parent acts, all the three acts. So I don't know whether.
But the whole idea was to revamp the parent act and start afresh, right?
That's a good point.
This seems like just copy pasting and adding a few more terms.
So in terms of suggestion, so one, my point was to make it broad. It's too broad, and also that second point on retaining right without any guardrails to broaden it is again a concern. And so now coming to the point of what are the recommendations or suggestions is, one, trim it down, like you said. Just take off OTT and take off as much as you can. Or you can include it and then say that they won't be having these kind of, so a tiered regulation. I won't go farther down that road because I have not discussed that in depth. But define, get it in under, but then figure out a way to tier stuff, which is what Australia, Korea, South Korea, maybe I think Singapore has also done. I'm just reviewing all these stuff. So I think that's kind of one approach, which is get everything in, but then figure out tiers. So those are the 2 points I wanted to raise.
Okay. Rishabh, Arjun, I'll come to you on M2M because we're discussing definitions. And as a founder in the M2M space, what are your concerns?
So I agree with you, Nikhil, completely in terms of that it's overbroad, and I would split it up into simple access versus content and have a definition on that basis. I actually did want to make the same point the gentleman there did, that it's useful also looking at the ITU's definitions of the terms as well as the ITRs themselves, which we are a signatory to, and the ITU definition also broadly speaks of transmission, referring to the process of carrying content, and therefore referring to the carriage layer. Also, just in response to the point that was made earlier in front, the ITRs again require countries to follow human rights norms in their preamble. So putting something like that into the preamble of such a bill would again, as Apar said, just sort of clarify how the provisions later are to be interpreted, which would be specifically useful in the context of surveillance, shutdowns, those kind of issues that we will get to later as well.
Lalit? Sorry, I'll just come after Arjun. Or go ahead and we'll come to M2M in a bit. Yeah.
Hello. I just wanted to hear a few views about this particular the definition, the scope of the definition, the width of the definition, in terms of a very let's say a realpolitik way of the way we have seen these sorts of reform or these sorts of legal movements happening in other subjects like IT, the IT rules, and with data protection. I want to just point out that in similar situations where we have had such extremely broad definitions, the movement from the first draft to later drafts has been in a very particular fashion, in a very particular direction. So, for example, in the IT rules, there was a broad definition of intermediaries in the Act. The IT rules could not change the definition in the Act, but then the broad definition that was the broad rules that were applied to all intermediaries in early drafts were later scaled down to social media and significant social media intermediaries in later drafts. There was this kind of movement. Then in something like data protection, extremely, just as in this situation, extremely absurdly broad applications of rules. Imagine mirroring all personal data of Indians in India. At the time, we had to engage with these kinds of ideas, despite how absurd it would sound to anybody else. All data of Indians, a copy inside India, how can that be? All personal data. We actually had to think about this at the time, and now see what's happened to it. My sense, over time, that has started to come about is that officers and departments are going about this in a very, to use a very blunt term, jugadu bazari way, which is to say that they put a very high price against which people have to now bargain, and then they get something that is still not very ordinary, like still they get some localization.
Right, so you're saying that this is a negotiation tactic almost, and let's start with the worst case scenario.
I don't understand otherwise.
This is a great point because we've seen that with the cybersecurity, the certain guidelines that came recently, we've seen that there, the JPC draft was quite horrible, so you're starting from a high negotiation point is what you're saying. It's a negotiation effectively, right?
Unless it's incompetence.
Okay. Let's look at it from a rational actor model perspective and say it's not incompetence but malice. That was also a joke.
So I think rather than malice or incompetence, it's tied to institutional history where institutions in government are used to a certain way of working, have a certain power, and any entity does not willingly cede power. So here the specific example I like to use is the possession of wireless equipment, which means our smartphones, which the government does have the power to license and regulate, but gives an exemption notification, and thereby we can go and purchase one without the need for a license. Most possibly, if you're my age, our parents could not do that without a license. So if you look at the consultation paper, it points to two laws, the Indian Wireless Telegraphy Act, three laws actually, then the Telegraph Wires Unlawful Possession Act, and it says its intention is to change this. But it's not actually changing it. Because if you look at the definition of wireless equipment, which is subclause 23, it means any telecommunication equipment used or capable of use in wireless communication, including any wireless transmitter that is capable of use for broadcasting. Most devices today have wireless transmitters, including our cars, right? And then you look at subclause 3, section 3, subclause 2, which is exclusive privilege. The central government may exercise its power under subsection 1 by granting any entity in the manner as prescribed. C, authorization for possession of wireless equipment. Thereby, it has now the power to prescribe standards but also license it, right? And then you look at subclause 3. The central government, if it determines that it is necessary in the interest of public interest to do so, may exempt from requirement of license, registration, authorization or assignment under subsection 2. So what makes it clear is it retains the exact power under a different name. Now, what can be the change under this? Of course, devices quite often are also registered for the purpose that when it is lost, or in a case of theft, the number of the device which has a unique code can be traced back to a purchaser by itself, right? And that by itself may pose problems of surveillance and data protection, but by itself for the general public it does serve a certain utility, right? But this power is not clearly defined. The work has not gone into it. And what has happened is an institution which has acted under certain laws for a certain period of time has only rearranged that language like a lazy intern, where interns most of the time work really hard. So just some perspective. I don't think so it's malice. It's a way of working they have been used to for a long time.
Then I guess that the pitch is wrong that we wanted
Yeah.
to look at it old.
Yeah, so it's not a revamp. That's why I've written again and again, Nikhil. This is a colonial law with different names. It has the same roots. It's not changed. Our thinking has not changed. It's not modern. The promise is not matching the actual output here.
Okay. Vikram, do you think there should be a separation of content from carriage? Sorry, didn't want to do so like a deer in the headlights thing to you, but you have that look right now.
Maybe I'll give it a pass.
Okay.
Because it's not for, it's not about, I hear much of the discussion. It's actually, one is to see the intent of the country as to what do you wish to do.
How would you see the modernization of the Telecom Act? Like this, or would you see it in a different way? Or you haven't made up your mind yet?
Not yet.
Not yet. Okay. Sorry, there was Vakasha. It's off here.
This is Vakasha. I'm a journalist. I wanted to just raise one issue which seems to be there, is that if we look at the recent trend of multiple things which have come in, right? Whether it was the IT rules, whether it's even recent things on the Press Act, which are also being sought to be done. One of the key things is regulation is almost like making sure there is a specific intention to regulate, whether it's social media, whether it's digital media platforms, which are not even necessarily providing communications as their key feature. And one of the things is that while that may not be the entire focus of this, the fact that all these things have been included.
What's so special about communications?
It allows that backdoor. Well, I mean, if we want to get into the reasons of why a government would
What
want
is
to control
what
how
on the
people can
what on the
communicate.
internet is not communications. Everything is a different form of communication, and it's like if you're putting a request for shopping and you're making a payment for it, that's also a form of communication.
I mean, so what I'm trying to say is that the problem is that I think we need to be aware that regardless of even if changes are made, given especially for instance we've seen with the IT rules, the challenges currently which are locked up in court because the IT rules got pushed through, it went through with a lot of things despite a lot of consultations, right? So is this again one thing to consider is perhaps that when these changes are going to be sought to be brought here, they are still going to be meant to be a backdoor to do a lot of the things which were being done through those as well. So even if we are able to try and suggest these kind of changes in terms of separating carriage and content, which I think is logically makes the most sense to do that because you would avoid getting into all these weeds. Since that is a clear intention, even with, I mean, I don't think we're going to be able to get them to agree to that change because that is the clear intention when we look at this whole line of legislations being brought through. So in some way or form, this is going to be included within this bill as well. So maybe we have to consider other ways to kind of protect that in other clauses within the act. I'm not sure. But that's, I mean, I'm not sure if I'm being clear. The idea basically being...
You are actually, so if you're saying that the intention is to try and regulate as much, which is the point that Lalit was also making, how do you salvage something is your
and the point is because
right?
they will. So we have to find, maybe we can consider other layers of protection as well rather than, I mean, the easiest way to deal with this is to...
Easiest one is to throw the messaging service under the bus and say protect everything else. That's the easiest way to do this.
Yeah,
but that's not the ideal way to do this.
I mean, so it's just that I think that's the thing we have to keep in mind that we have to look at other provisions which might allow some sort of checks because this is going to get done in some way or form. I think
I would look at it from a different angle. I mean, we did this during net neutrality. I mean, if it's a negotiation and someone's taking away everything, then you ask for everything. That's how if you can't start from a negotiation from a weaker footing, right?
No, I mean, I agree with that. It's just that I guess whether how
push for 100%, you just might get it. We did. We did.
Nikhil, I was just wondering if you have thoughts on the UCC provision. I mean, because that.
We'll get to that.
Oh, okay, fine. Because that's also content in a sense.
I have a, I mean, I have a lot to say on that, but Mr. Maheshwari is waiting actually. Sorry.
So three things. One is when we use the term Indian Telegraph Act 1885, I think we should just do a small
I have
scan.
to ask you this. Were you around when it was passed? Sorry, but he remembers everything and every date, and I mean, he's an encyclopedia. I love him for that.
So
Bad joke, I know, but sorry.
1st October 1885, that's when the Indian Telegraph Act was, of course. So if you look at India, Pakistan, Bangladesh, obviously it's natural that all of them will have Indian Telegraph Act 1885. But please look around the other countries. Look at Malaysia, look at many other countries, you'll find Telegraph Act 1885, language ditto, okay? Because it all came from one place. And so that's one historical perspective. Second thing is, most of the new telecom services in this country got licensed, not now, actually in the 90s. That's when we got licenses for things like I am saying, email. There used to be a telecom license for email in this country. Internet also started that time. VSAT, paging, PMRTS, even mobile, etc. The government did not have to change the definition or anything for that matter in the Indian Telegraph Act 1885. And even now, when the 5G was launched just a few weeks back, we didn't have to relook at the definition of the Telegraph Act. So I think that from definitions perspective, that act is so good that a good lawyer like Apar could even argue that even telepathy needs a telecom license. I hope that he doesn't, but I'm just saying this. The third thing is, if you look at the current act, although it is called the Telecom Bill 2022, the fact is in 2001 also we had this Convergence Communication Bill. And I would say that yes, despite the fact that whatever many other else that particular bill had, but even then that particular bill had, I'll say, overall a better structure and a better intent and checks and balances than the current one has. Thank you.
You think we need to go back to that convergence bill?
I think that's one should be dusted off, revised. I'm not saying should be done as it is, revised, and then sort of discuss further. Because even now, we have the situation that the government is talking about a cybersecurity policy. We are talking about a data protection bill. We are talking about this telecom bill, and of course the non-personal data policy, etc. But if we go back 11 years, Kapil Sibal had come out with 3 different draft policies on the same day: electronics, IT, and telecom. So even if there are 4 different instruments that the government is thinking, suppose you come out with those drafts on one single stroke, then at least one can see what are the gaps and overlaps. Otherwise, what is it that we are doing right now? We are looking at the telecom bill which came recently, data protection bill as and when it will come, and we don't know what else will happen.
We don't even know what the Digital India Act is.
Overlaps.
Correct.
Hi, this is Shubham from Quantum Hub. My question, so there's a lot of discussion around separation of carriage and service. We have seen legislations across the world. Singapore had a broad definition for telecommunication service, but then we also find them defining specifically the service layer as well as the network layer within the Parent Act. This sort of a defining structure can be found in the American Act, similarly in Australia. So my question is, and if we see the VNOs specifically in India, so the Indian government seems to take a licensing route towards the unbundling of various layers in telecom. So is this a missed opportunity since we are, again, coming up with a new legislation? So should this sort of a distinction to make it more clear, and we are obviously advocate.
Sorry, I didn't get your point.
So my point is that our obvious solution that we identify here is the separation of network layer and application layer.
Correct.
So the particular definition for that, should it be present in the Parent Act, or we have seen it in the case of VNOs that the Indian government has taken a licensing route towards unbundling. So is this a missed opportunity here?
Yes. They need to unbundle. Sure. Arjun, what are your concerns with licensing? You run an IoT M2M business.
Okay, so I'll be very. It's on. Okay, so I run a business which is in the intersection of clean technology and telecom. And my biggest concern with regulation in India is that whenever you have multi-sector approach, first of all, you have multiple operators or multiple regulators coming into the picture. In the past, I've seen how, and this is like 15 years back when the fintech industry was taking off, just taking off. I wouldn't call it a turf war, but yes, in the very early days, there was an issue as to who basically would drive the policy and drive the innovations around fintech. The telecom operators had their own KYCs and their own regulations, and RBI came down with a fiat saying that anything to do with money is our domain, and then it took a while to sort that out. And frankly speaking, fintech entrepreneurs will say that it is still work in progress. So my biggest issue is that innovation and people like us will obviously be working at the ultimate edge of whatever the technology is available. And we will always have legislation which will be catching up many years later. As far as I'm concerned, I'm right now grappling with the new policies which are coming into batteries and EVs and those definitions, and trying to and those definitions include communication onto the cloud, and then you have the non-personal data. We have M2M,
So how many
licensing in a way coming in.
How many licenses will you need?
I mean, yesterday a customer told me that you would probably need to get your software certified by ICAT. I said no. I mean, it doesn't mention anywhere in the rules. Probably our interpretation is like this, and this is what is happening. So every innovation that we do, we go 10 steps ahead, and then we always look back to see that where is legislation right now, and if we have to do a backwards catch up, let's put it this way, this is the way it happens. Right now, for example, every M2M provider has to register in the DOT portal that he or she is an M2M provider.
So we'll come to licensing shortly.
So I don't know if it's licensing or if it's just a registration, because I'm not clear. My company secretary and lawyers are doing it. They made me sign a few things and they've done all the uploading, and I just left it at that. I'm busy running my business right now.
No, I'm actually wondering about SaaS in particular, because if you look at Fresh, which was started as Freshdesk some, I don't know, 10 years ago. Beat Zendesk globally is India's is a listed company on NASDAQ, and great guy Girish Mathabhutam, he spoke at the first NAMA conference in 2012. They would need to buy a license under this to start their operations, because they started off with customer service chat and stuff like that. So and then built CRM and a whole workflow around it.
And what happens when you start handling international data? For example, I could just go and sell my platform to some international customers, have the entire data hosted here, and then manage the operations for that customer on a remote service model or managed service model like in telecom. What license do I have to?
Which is why hundreds of SaaS companies from India. I was in San Francisco 2 months ago, and the person from Silicon Valley Bank was saying that 100 companies were over here at a conference yesterday, all of them looking to move to Delaware from India.
Singapore has been anyways.
Singapore's is now going down a bit in terms of preferences.
Historically, the place.
Dubai has gone up. There was like almost 60 Web3 companies that went to ETH Dubai.
I've been told Canada is a better option.
Everyone's moving out.
Hi, I'm Harsh Walia. I'm a TMT practitioner. A lot has been said about the Telegraph Act as well of 1885. I think if we want to understand why telecom services per se has been tried to be defined, one of the reasons that comes to my mind is that the earlier legislation talked about telegraph and not telecom services anywhere. So what it said was establish, maintain or operate telegraph. And if you look at the licenses, the UASLs and UL, they all talk about telecom services. They don't talk about telegraph. So there was a big disconnect of what is there in the allocation of business rules that the government can make rules on, what the Telegraph Act said, and what we were actually regulating. It never came up before the courts, but yes, that was a disconnect. I think that could be one of the reasons why telecom services is defined. Now, coming to the question whether it has been defined properly or not, I definitely agree that it is not.
How
The
should it be,
the
in your
the
opinion?
best way of defining it.
How should it
And
be?
yeah, the best way of defining it, I think, see, the one of the reasons that I understand DOT must have thought is to make it wide so that they don't have to change it every time. So they made it very, very wide, but that has other problems in it. Now, I think it has to be defined in a manner where everything, because to give you an answer to this, I need to understand what they want to regulate. If they only want to regulate WhatsApp communication, for example, then it should be defined accordingly and not the way it is currently, that all internet-based communication, interpersonal communication, those kind of
You can
vague
take an IT
terms.
rules approach, right? You can say that messaging services with users above 500 million monthly active users in
Correct,
India
correct. So
should be regulated, which leaves only one.
if that is the
Or it also has
intention,
the email
yeah,
actually. It
yeah.
could contain do email as well that way.
So I'm not saying they should be regulated. I'm saying if that is the intention that it should be regulated, let's not make it ambiguous and vague and clearly say what needs to be regulated. If the definition has to be made wide, then exemptions should be worked upon very carefully in my view.
So let's now get to. I just wanted to also check. Does anyone think that social media, which is part publishing, part communication, would also be covered under this, or you think not under the definition of telecommunications? Would it, does the definition cover social media? I think it covers chat, app stores. Anyone? Does. It does. Okay. There's nothing it leaves out.
I just actually went back and read the definition of telecommunication and telecommunication services. So, telecommunication services is service of any description made available. Just a second, sorry, I'll open it again. So, service of any description which is made available to users by telecommunication. I mean, forget the portion in the bracket for a moment because that is just inclusive. It's just illustrative in that sense. If you go by this definition, literally everything is within its scope. So whether it's social media or not, because even your kirana store will message you something on phone to tell you this price or that price or anything for that matter, because it says made available to users by telecommunication. So the service has to be made available to users using telecommunication, which is nothing but transmission of messages. So if you look at it that way, I think what we need to amend is not just the definition of telecommunication services cannot be services made available to users by telecommunication in that sense. So I just wanted to add that in my view, everything, any kind of communication, any kind of business
Correct.
is within that scope.
Human or not human, because it has M2M as well. I was just, this argument we've heard in the past as well of same service, same rules. If you ignore the content versus carriage sort of thing that we've been talking about, don't you think there's a rational argument saying that telecom operators make money by providing voice services, and now you have another service that's also providing voice services, albeit over the internet? Shouldn't the same regulations apply to both? Anyone?
I would differ from saying that. See, I'll start by quoting the AGR judgment, where the Supreme Court specifically quoted about the part of the sovereign, where the sovereign grants the license of, grants the spectrum, and spectrum being, something of the public. The fact that spectrum is licensed out because it belongs to the public at large, and public has given to the sovereign, and that's why it is coming out. But when we now talk about the when we now talk about the carriages, and when we talk about service providers, and maybe at some moment both of them are providing at least similar services, if not same, under what tier will you include them? If we say the same regulation should guide, say PUBG for that example. PUBG is a game which also has chat services, which also has the ability to where the players can. Yeah. So okay. Yeah. So be it PUBG. So be it PUBG also includes chatting services, communication services, and at the same terms we're also seeing WhatsApp, which also includes chatting and calls, and at the same time we're also including the carriages like say like Airtel and BSNL. They also include the same services. So you mean to say that are we including all of them under the same bill? I differ. We should not.
That is an argument that's been made that they should be in the same, but Venki? Okay.
Nikhil, I'm sorry, I'll have to leave after this. So, even a smaller point, I think, so which is much more personal to me, and I think animates the larger drafting in this, which is a replication of the Telegraph Act, is the actual phrasing of the power of licensing and registration as exclusive privilege. Democratic governments do not have privileges; they have functions. Hence, it's very easy for the central government to change the phrasing of Section 3 rather than exclusive privilege to functions of the central government, and to drop the references to exclusive privilege in subclauses 1 and 2 as functions under this act. It won't change much, but it will also be much more reflective of the constitutional grounding of this law. It will improve even it for all of us, and maybe in the minds of officers who will exercise functions under it much more formally. So that this change will reflect more in terms of its enforcement into the day-to-day, I think much more socially, and I think this is important. So just wanted to make this limited point.
So how should it be?
So Section 3 is headed exclusive privilege. It can just be phrased as functions of the central government. Subclause 1 is central government shall have the exclusive privilege within India too. It can say the central government shall have the functions within India too. Section 2 says the central government may exercise its privilege under. So it may say central government may exercise its functions under subsection 1. It's so easy.
But then, so you're basically removing the exclusivity there, right?
No, it does. It already does. That's under list 1. It does have that, but it's a constitutional power to make law, and the law is saying, even if you look at mining statutes or any other natural resource allocation, it's essentially either having the power to exercise certain functions or directly exercising certain functions or regulatory functions. It's defined like that. This exclusive privilege business is no longer there. So it's outdated drafting, which then reflects in certain attitudes which are present in bureaucrats. And when this changes, we know that law has changed. It is modernized. So that's why I think this is important beyond lawyers like me caring about it. Okay.
Well, even in those exclusive, like one of the points that I was making to someone the other day was that if you think about it, I'm just surprised that that Wi-Fi is not licensed and regulated. We just got lucky that they didn't see monetization.
No, there's an exemption notification, Nikhil.
Exactly.
So at a certain point in time, they didn't do it. Then they woke up one day, and then they retrospectively give an exemption notification for smartphones, for certain wireless bands, and the existing equipment became legal at that date for your past use and for future.
Okay, so basically the market got ahead of, like Arjun was saying, the market got ahead, and then they had to retrospectively make it legal
even
because
prospective, retrospective, and present. But they basically couldn't keep touch with the powers they had.
So if there are even aspects of the functions apart, do you think before you go, are any of those functions that need to be
I
done
think
away
what will
with?
be useful, much of our thinking comes from my colleagues at IFF, but we'll do we are attempting, and it takes work to do a redlining of this, and we'll try now. Thankfully, the ministry has extended it by 10 days. I know it's not that thankful because it eats into our Diwali breaks for everyone, but we'll still put out a red line in advance, so it may be of use, and always appreciate others doing a copy paste, whether it be industry or civil society, and we do it as well. So we draw from others because it helps a lot of times focus on agreements and take forward a common objective.
Yeah, but the next data protection bill is going to be out December 23rd.
Really? No, December 25th. You're
before
forgetting.
Christmas.
It's always 23rd to internal stakeholders, 25th to us.
To us. Fair enough. Thanks for coming, Apar. Great interventions. I want, sorry, Mr. Uppal, you want to say something?
Same service, same rule you were talking. I think the same service, same rule is actually quite a problem and quite poorly presented in my view. Couple of things. That for a start, irrespective of whether the same service is provided, they're provided by different players in different types of markets, etc. So they are not peers. But the more important thing is that no economic regulator treats all providers of services equally. If you're an economically dominant player, if you're a market dominant player, you're regulated differently irrespective of the service being similar. For instance, I mean, in the British case 20 odd years ago, I mean, British Telecom, which was the incumbent, was regulated far more severely than the competitors were in terms of license fees, in terms of tariff regulation, blah, 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 all that. And a third thing, which I think is often forgotten by the proponents of the same service, same rule, is that they don't actually believe in it themselves. If you recall the arguments when we moved from paging to mobile phones, they were the ones who said this is the advance of technology. When paging people complained that, look, you guys were doing the same text messaging that we are doing, but you enjoy better terms and conditions. Secondly,
this is another example. You have vast content. For example, there's mobile radio.
Exactly.
Why don't they have an FM license? You have you use your mobile balance to pay for content on the operator network.
Yeah.
Why doesn't that require a wallet license or a payment gateway license?
Correct. And a third one, of course, is something which is even more, I think, worrisome, or not worrisome, more interesting, which is that they themselves, the proponents, are perfectly happy that the entry fee for Delhi is different from that for Bihar. They're perfectly happy that the reserve price of spectrum is different between West Bengal and let's say Jharkhand or Delhi or whatever. It's obviously the same service, but clearly they don't really apply that rule so consistently as is implied. So just a point. Thanks.
It's okay. I remember during the net neutrality debates, you had a situation where the submissions to the TRI were that we'll lose money, we'll lose market share. At the same time, earnings conference calls. I remember Airtel Gopal Vittal saying that VoIP is not a problem. We're making enough money, and this will only add a revenue stream.
But even if
different statements to different stakeholders,
even if it is true that money is being lost, even if it's true that the services are adversely affecting the incumbents, the point still remains that same service, same rules do not actually apply. They make little sense in economic regulation, and they don't even make sense in the Indian context where they're being applied or where they're being advocated.
So I don't know if anyone has an opinion on this. Yeah, Niti, I'll come to you. I just wanted to also check this question that Indrajit Sarkar had asked in the sign-up form, that is there a case to rethink exclusive privilege over services as opposed to spectrum? Great point, but...
Yeah, just a couple of thoughts, and maybe some of this debate hasn't come to India very, very, purely, but it is making itself felt, especially in the EU, and South Korea has passed regulation on it, something called send pays proposals, right? I have a problem with this because, when we're talking about free riders, especially in the internet space, what telecom service providers have often had beef with, but they don't realize is that applications, especially, platforms so widely used as the ones that we're discussing right now, they create demand. And therefore, they also create a lot of people signing up to better and more pronounced services, which then TSPs do monetize.
So I don't understand what is free riders. I mean, we had the same argument that we faced earlier. Uh, I'm running I'm running an online publication. I'm buying service space. I'm buying bandwidth space. As a part of that cost, I'm actually paying for access to the internet, just like anybody who's accessing my site is paying for access to the internet. There is no free riding. I'm already paying for bandwidth somewhere in the world.
Exactly, and that's what these proposals, which are being heard much more in the EU, and they've also passed in South Korea, do not realize is that you cannot charge a service twice, because they are already paying for domain space. People are paying for things like Wi-Fi, bandwidth, etc. So to then say that oh, this is a free rider just because they are creating so much demand on the network, they are creating demand and therefore you're being able to monetize it. So the free rider argument doesn't hold for these services. That's my first problem. My second problem is with integration. So telecom services, especially like voice and text messages, are vertically integrated into these networks. These networks are formed for services like voice calls and text messages. But when OTT platforms, applications, and they want to innovate over this general purpose.
Internet platforms, OTT, the telecom
Internet
word.
platforms, when they want to integrate themselves onto this general purpose network, they are the ones who have to pay for innovation and development of that network, for the network to then serve their purpose. So a very good example to think about in this regard would be streaming services. So the internet wasn't built for anything in particular. It is a general purpose network, right? If you want your service to have fluidity and flexibility over this network, you have to then innovate over the internet stack, over the layered infrastructure of the internet, to then be able to have your service experienced with a certain level of fluidity and without interruptions. So service providers such as Netflix, such as Amazon Prime, are already paying a lot in terms of innovation to be able to have their services integrated into this network.
It reminds me of a story of a guy I met at a bar in Beijing once. He was teaching English in Beijing, and he was talking about how he had been one of the early employees at one of the largest pawn networks in the world. And he said the amount of work we did on reduction of video bandwidth is basically what the world has benefited from. Sorry, I just reminded of this one, like the guy I met at the bar.
I just want to add something here. When TSP argues same service, same rule.
Louder, please.
When TSP argues same service, same rule, they ignore this fundamental distinction that TSPs and...
Can't hear you, you'll have to speak up.
Am I audible?
Yeah, now you are.
So I'm saying when TSP argues this argument of same service, same rule, they ignore this fundamental distinction between the TSP and other entity that are providing voice over internet protocol. TSP, they own network, they have ability to access spectrum, and that's not the case with other entity. And that's why this argument does not have any ground. And the better way would be to separate the content, carriage
from
and
carriage. And
yeah,
we've
carriage
discussed that.
and that would address the concern of TSP, that other entity they are providing voice call without holding license.
So
that would
TSPs don't
also
want
address the
separation of
concern
content from
TSP.
carriage, right? Yeah. I'm going to keep needling you. Sorry. So that one point about exclusive privilege over services as opposed to exclusive privilege over spectrum. Anyone have any thoughts on that aspect?
Two quick points about this. Firstly, of course, because of the Supreme Court judgment and the political issues of the last 10 years, spectrum as natural resources become sort of de rigueur these days. So maybe that is one of the reasons.
What does de rigueur mean?
Well, it
I'm
just
not
means
a lawyer,
become,
so-
so sorry, I'm sorry for using bad phrases, but de rigueur just basically means it's become like an accepted thing. Everyone thinks it's very important that spectrum is a natural resource, data is the new oil. I think this, when we think in cliches, we kind of lose the perspective of clarity, and we sort of become wedded to these cliches. The second part, the Indian Telegraph Act was the colonial legislation. So for the government, for the British Indian government to pretend that they had the exclusive license over everything is one thing, but for the Democratic Indian Republic to say the same thing 150 years later is something quite different. So I mean, I think that this exclusive, again, you see, there is a difference between petroleum, upon which for which the government does actually have an exclusive right, versus something like data or something like telecom services. So
how would you change it?
no, I agree with the power over here. I think the fact that the exclusive license language has to completely go. It's one thing, for example, to say that spectrum can be used in particular ways as licensed by the government, and of course the government should have every right to make sure the processes for others are formal and safe, etc., for everybody to use fair. But it is entirely different for them to say that services which utilize this also have to be regulated. What does it mean that the government have exclusive license to provide the same services as WhatsApp? Clearly they don't.
Any counterpoint, any thoughts? You have a point there? Okay. Please just bring a mic to you. So just before you start, there's a question from Rohit Su. Is Rohit here? Okay, there's a great question. Is it compulsory for cloud data services to remain in India post this bill? Sorry, go ahead. We'll come to this question next.
Just to elaborate on that sovereign power, exclusive, I can't say what the sovereign power and everything should be there. That is yet to be examined. But the point is, today if we see the definition of telecommunication service, today broadcasting service has also been brought under that as a telecommunication service. Of course, we always needed a permission under the uplinking, downlinking for a news and current affairs or any other thing. That is more an act of freedom of speech and expression. That is more the freedom of press or anything related to that. Now, is freedom of press, the freedom of speech and expression, is it an exclusive power of the sovereign? Now, you know, these are the constitutional questions which would arise before we examine.
That's a fantastic argument.
Yes. So, you know, because ultimately, even the social media is a medium for all of us to freely express ourselves.
So are you saying that the constitutionality of this particular part of the law can be challenged under 19(1)?
It has to be, because ultimately if the government is going to go and hold that it is my exclusive privilege to determine what you are going to talk or how you are going to work or under what terms you are going to work, then I think we have a serious problem and we have a serious constitutional issue to face.
Does anyone want to question this, disagree, agree?
Yeah, I mean, I'd love to agree in terms of how we could sort of protect our liberties, but the exclusive sort of power of the government to license spectrum is something that is seen across different jurisdictions. So it's going to be very hard to fundamentally get completely removed from that idea. But looking at it as a functional perspective, right? And why did you have? So that you create a communication network that is interoperable and you're able to innovate and provide services in that. So you need some entity to license it and ensure that these bands are for these services and that your networks are operating fine. So I don't see why that should be something that you want to take away from the government or question fundamentally.
Spectrum is a carrier of speech. For the government to claim exclusive privilege over the carriage of speech and have the ability to license it.
It's an extension of the argument.
No? Won't work?
It would be difficult to argue that the government does not have rights over natural resources. That would be a very, very... Spectrum is a finite but natural resource. It's not something that anybody else could claim ownership of other than a sovereign government. So in that sense, it gives you the rights to use it, but I think you could argue that natural resources do belong to the government in that sense, or whatever the legal extension of that is. I don't know, I'm not a lawyer.
You're thinking about this, right? I can see.
Well, as a constitutional lawyer, I'm much more pessimistic about this. I would imagine that if a challenge does arise, it'll be a localized challenge based on particular facts. Nobody is going to say that use of spectrum itself is not a sovereign right, but they might be able to say that particular services being regulated in a particular way would violate free speech. Clearly, I mean, there is going to be a chilling effect for sure. If the requirements imposed on say messaging services are very severe or email services are particularly severe, if you have a broad range of regulatory requirements which apply to all telecom services, including these people, then naturally they will certainly argue under their right to free speech 19.1a and the right to carry on their profession 19.1g that they are being unfairly targeted or that this is disproportionate in their particular circumstances.
So expanding overall control to to communication services and having the exclusive privilege to license them might.
I think it might, in the sense that, I mean, I would imagine it depends upon how open the court would be to this sort of inquiry. But this, I mean, in India, it's not generally the law that whatever is, everything belongs to the government and government licenses us to do things, The rule always is that we can do what we feel like, and when the government thinks it needs regulation, then it needs regulation. So, I mean, the kind of reversal of this is actually quite funny, which is, like I said, maybe it's a colonial hangover from the days of the Indian Telegraph Act.
No, and that's what I'm saying. It's probably open to that challenge then. Anyone else want to jump in? I'll come to you, Lalit. Sorry, someone there as well? Okay,
Hi,
there.
hi.
So just here, there, there.
Yeah, and I think it's a interesting point because a long time ago there were newsprint laws that newspaper was allotted newsprint and you can't publish more than 10 pages, and it was challenged under 19.1a. So that's also, isn't it similar that you're actually controlling the mode of publication and thereby controlling free speech?
Yeah, in Sakal papers, but you would sorry. Yeah.
Hi.
Sorry, just two very quick points. One, I think.
Mic up, please.
Sorry, yeah. Just two very quick points. One, I think that's very correct. I mean, it is a very strong 19.1a argument to say that the economics of some kinds of speech are being made a little bit tougher. So I think newspapers have long used that argument. I'd expect digital entities to also rely on a form of that argument. The other thing I wanted to say just on this exclusive privilege thing is it might be a bit of a red herring insofar as it is clearly a colonial hangover. It is clearly something they're carrying forward from a drafting practice from 1885, but functionally the government could achieve the same goal by saying no person shall operate a telecommunication service unless they're registered under this act, which is what they do under the Cable TV Act.
So I actually have a registration question as well. I'll come to that in a bit.
Right. I mean, my limited point was that I think focusing on exclusive privilege is jurisprudentially interesting. I'm not sure functionally it makes any difference because there's 10 other ways you can draft a clause that achieves the exact same purpose.
Yeah, I just thought that in terms of Article 19.1, it would be good to keep in mind some very fine distinctions. When we are talking about the medium by which speech is actually communicated, that has to be kept separate from the actual speech act or the expression itself. For example, we can't consider telecommunication wires to be something that is actually speech itself. It is something that carries speech.
But isn't protecting the carriers of speech as important as protecting the speech itself?
I still agree with the implications of what has been mentioned earlier, that there are ways in which one regulates the mediums that can be having a chilling effect on this. But to simply say that any claim of the government over spectrum, any public trust that the government has over natural resources that relate with communications is itself a violation of 19.1a is, I think, not tenable. So that's just simply the distinction I want to make. I agree with the latter point that there are ways in which this can have chilling effects.
I'm Ratan from SFLC.
Louder.
I'm Ratan from SFLC. So I have one question which flows from that government controlling the medium will not actually affect the speech itself, the distinction between the act of speech and the medium. If we extend that principle, then even controlling access to internet or an internet shutdown will not be a violation of free speech. Do you think that's correct? First, and second thing, I think control of OTT platforms, telecommunication services, including OTT platforms, and the way
Internet, not OTT.
OTT, yeah, sorry. And then including that in section 24, where they can intercept or take away the access or control it, also has a lot of free speech implications and chilling effect.
We'll come to lawful interception
Yeah.
immediately after this, so hold that thought.
A quick response?
Yeah.
Yeah, so I think it's entirely clear that if you shut down the internet, that is affecting, sorry, if you shut down the internet, that is purely stopping the expression itself, stopping the actual speech act itself. And it is via the mode of affecting the medium. So that will fall within what I was talking about, that there are some ways in which you can regulate the medium which will impact speech definitely. But the implication of saying that any regulation of the medium is a restriction on speech is quite grave, because there is no ground in 19.2 which allows you to do ordinary regulations of the medium like registration, like licensing. There is nothing in 19.2 that allows you to do that. Unless we don't want any of that to happen, we can't say that merely regulating the medium equals to restriction of speech. That was my distinction.
So I'm going to ask Siddharth this. In terms of the, and I didn't want to jump into internet shutdowns right now, but just taking off from that point, switching users mandatorily from 4G to 2G does not effectively shut down access to the internet, but it does have effectively a diminishing effect on speech. So I'm just wondering about Lalit's argument here. Is that not a restriction on speech?
I mean, I would say that, like, for instance, any...
Mic. It's on, you have to hold it up.
Okay. So I would intuitively think that if there are, like, decisions by any state authority to diminish the speed of the internet, which did happen, of course, in Kashmir for a prolonged period of time, that would inherently, of course, have a chilling effect on a few different dimensions of speech, but more specifically the right to seek, receive, and impart information. And especially in the context of when you diminish the speed, often a lot of the websites which are developed over the internet are built with the understanding that there will be a certain type of bandwidth which will be available for the consumer who is accessing their services. So in some ways, when you reduce the bandwidth available, then a lot of websites and content and application and services
so by that same
become sort
rationale,
of unusable.
So by that same rationale, if you reduce the number of services that are allowed to provide messaging in a country, would that also not be an act of diminishing the ability to impart speech? Or
I mean, it'll definitely hinder consumer choice, and in some ways it'll also compromise their ability to be able to access better types of services to communicate in more dynamic sorts of ways. So for instance, if I use a WhatsApp and a Signal for different purposes, and Signal becomes unusable because of whatever the conditions are under the Telecommunications Bill, then of course my ability to communicate with certain types of audiences will be compromised. People who don't use, for instance, WhatsApp in a foreign setting, for instance. So my ability to get my voice out,
Yeah.
not just domestically, but also internationally.
And the same
as
logic
well,
applies to,
will
for
be
example,
compromised.
video. If let's say today I can go on YouTube Live and Medianama can stream this discussion live, and now if you say that I'll have to buy a license or I'll have to do a registration in order to do this, then that has the same chilling effect or restriction on people's ability.
I mean, so of course there will be a chilling effect, but I will say that, for instance, we will have to consider if, say, for instance, litigation were to take place, if the restriction on free speech and the ability to sort of impart information has been restricted sort of in a reasonable manner, and then you'll have to go down into the nitty-gritties of, you know, the lawfulness, necessity, and proportionality tests which have been laid out in Indian jurisprudence. So it becomes a highly like fact-specific situation, but of course, like when these sort of disproportionate conditions are created for people to be able to use services to get sort of disseminate their voice or their information or their content, there will be like sort of discussions that need to take place from a constitutionality perspective as well, I would say.
Okay, by the way, it looks like we're going to go about 45 minutes over time, just letting you know this. We still have a whole lot to discuss, so quick answers. First Neha, then Aman. Then I just want to have one last question for this particular segment, but Sneha.
Thank you, Nikhil. Just on the medium versus speech point issue, I wanted to make 2 points. One, on what Raj sir said, picking it in 19.1a, controlling medium will have an aspect of controlling speech economically. We have the Sakal Papers landmark judgment that is very clear on this, that if you are by way of controlling the medium, trying to put some economic restrictions that will impact speech, and therefore it has to be within the four corners of 19.2 alone. It can't be beyond 19.2. So that is one aspect. Second, again, we have to keep in mind freedom of speech is not absolute in India, because of which, and we have constitutional recognition now that the medium of speech itself is protected. Internet is protected under 19.1a, which means that even if you bring it down from 4G to 2G with an intent to restrict speech, which is outside the four corners of 19.2, that would, again, I think, be open to challenge. So I just wanted to make those 2 points. You have enough legal sound landmark judgments to support both these arguments.
Okay, we'll go to the internet shutdowns immediately after this because we've already started that conversation, but Aman.
Sure. Thanks, Nikhil. Actually, just building on what a lot of people have said, my comment and question for this larger group is how worried should we be right now, right? Because I think Apar made the point that nothing has really changed. It's still being it's same stuff being repackaged. Rahul spoke about, it'll have to be fact specific, and we're talking about challenges, in terms of what facts could arise going down. But if we just go by how exclusive privilege is defined, and let's look at 2 and 3, a lot of it is still left up to subsequent regulations which are going to come, manner which may be prescribed, they may grant exemptions. So as of today, yes, it covers everything, but that's not necessarily changing what the government could do earlier. Today, we don't know what those regulations are going to look like in terms of what they will require a license for, what they will not require a license for, and then the conditions which apply. So, how worried do we need to be?
Ashwini Vaishnav also said that we will take a light touch approach, but the point is that by the looks of it, the law still is not a light touch approach. So, if your intention is to not license, it is only to, let's say, have registration, then why not have that in the law instead of keeping the door open for licensing everything under the sun in the future? Mm-hmm. Because the law is indicating your intent, right? Even if you're not, like, we've seen how regulation evolves. It opens a little bit, then a little bit, then and the whole thing, it expands. Its scope,
they've kept the door
its
open,
impact.
but we don't know exactly what's going to happen with that yet. So that, just wondering if anyone else thinks that, do we need to wait?
Do we need to wait for what?
Yes, of course, we push back right now. We argue for sort of narrowing definitions, etc. right away. But do we need to actually wait to see what the manner in which things are prescribed comes out? To actually say, if we were to mount constitutional challenge to it. Without that, can we even do that?
There's a question that someone put in the form. What's wrong with a general authorization approach? And anyone else want to?
I'm not sure if this is my question, but I'd also put this in because, see, the reason the definition is problematic is because it's broad. I agree it's broad, but that is how we legislate in India. Like, that's not surprising. The problem is the fact that there seems to be an intention to license all kinds of services, and there doesn't seem to be.
So we've covered all of that.
And the fact that the missed opportunity is that there is no conversation about general authorization. There is no tiering happening over here. So I think even if we do push back, I think it has to be on that, not so much on the definitions, but more
on what?
On adding tiers in licensing. Like this gentleman over here, he made this point about how you restrict licensing only to, let's say, scarce resources like spectrum, and everything else you might allow through general authorization.
Well, why should you have a general authorization remit in any case for everything else?
Or you create different tiers based on how.
Question is why?
Because not everything requires the sort of licensing that they want to add.
But not everything requires authorization, right? The thing
Yeah,
is.
so then you have open entry tiers as well. You don't.
Okay.
My point is that you need to have more tiering and more options over here, and that is something that is missing over here.
Okay. Uh, if we could just move back in over here once you've got your tea, please. Anyone wants to quickly go and get tea? Go ahead. We will continue the conversation though. I don't know. Anyone else has a view on the general authorization bit? Like, should there be?
See, that is the current position in any event. Ultimately, the permission which a broadcast license gets is a kind of authorization only. That yeah, you're permitted to do that subject to fulfillment of certain conditions. But today, going by the definition, today it has taken a new color altogether. Today, everything I think it is completely unambiguous in the way it has been worded. Though Modi ji wanted a simpler language and all that, the problem is in the entire zeal, he has brought everything under exclusive privilege, because if we see the telecommunication service, that is broadly defined.
So how will you change it? What Apar said that it should be functions?
He needs to be clear. The definition needs to be clear that what is exclusive privilege and what is an authorization or a permission, or which needs an intimation probably.
I think John is agreeing with you right there.
Yeah, so that's precisely the point I was coming to on the exclusivity of the central government. I think we've said this before, and I'm going back a little bit, but I think I'm not a lawyer, but there's an eminent domain principle when it comes to natural resource.
Including people, by the way.
Yeah, and I think that's where government has that exclusive privilege. But I think I also agree with what Apar said about the list one, because it's telecommunication services, and this is not a regulation of spectrum alone, which is a natural resource. It's just that telecommunication needs spectrum. So there is the element of that. So this is more of a question I had when this whole point was discussed, because that exclusive privilege of the government is something to do with a scarce natural resource, which in today's world is a question in itself.
You're
right?
making the content carriage point.
Yeah.
So we've done that.
Yeah. But I think the point to which Raj was referring to is that the licensing, what should be licensed and what should be, let's say, registered, and what should just come under general authorization. That distinction has to be, the principle for it has to be very, very clear. Right now, if you look at the bill, it looks like the exclusive privilege is being applied to the entire broad definition of telecommunication services.
Why aren't we talking about deregulation instead of increased regulation?
Yeah, that's, yeah.
Vikram, would you like deregulation of telecom? You should have a view on that.
Thanks. See, the point is, since telecom is dependent on spectrum, right? And why do you have regulation for spectrum is the issue. The need for regulation for the use of spectrum has been recognized internationally because you need coordination. You see, wireless cannot, or electromagnetic waves cannot be used without coordination. That is the reason why you have the ITU and the World Radio Conference, and you have, international understanding and definitions of how to use radio frequencies, right? So that is the need for regulation. And the other part is about, okay, that part is regulated, but the unregulated part, what should be unregulated is, if you're not using spectrum. That is the other part that we are discussing.
Everything that's not using spectrum should be unregulated. It's just...
that is something which, you see, in the recent past, if you see, what's been the impact of society, right?
Let me
in
put
fact,
differently.
I'm reading this very interesting book, by Anirban, Prasad, what's his name? The impact of technology, right? The impact that agriculture had on civilization. Similarly, the impact that digital services is having on current civilization. And that's where, governments are trying to figure out stuff.
So become everything that's on the internet is already regulated. There's an IT Act, etc. I'm just saying that everything doesn't necessarily need to be regulated under the Telecom Ministry or under a Telecom Act. So where there's spectrum involved and there's carriage involved, that be the Telecom Ministry's remit. Already we have a lot of regulations for everything else anyway in place.
So, there is, the question is now open actually. India did attempt the convergence part, as Deepak mentioned, right? Now, the question now one can debate is, do you need these three separate, approaches to controlling digital? Right, it's figuring under the Telecom Act, the Privacy Act, the Digital India Act. So, because in the end, everything is, boiling down to bits. How you're moving bits around, to deliver different services. And there are different people going to control that part is something one needs to address.
Great.
No, I think I'd agree with Vikram on the issue of spectrum. There is really no running away from the fact that spectrum is a scarce resource. It has
mic up.
Sorry. Yeah, is that better?
Yeah.
Yeah. That spectrum is a scarce resource. It's a natural resource, and if not regulated, it can cause huge and harmful interference
Wait, so
with.
what do you have to add to what he said?
Yeah. Okay. So what I do want to add to this is that, for example, in the European Union, actually what you do regulate only is the part which is scarce. For example, you have a license if you need a license if you're using spectrum. You need a license. Only licensed people can use numbered resources, for example, numbering resources, right? So really, it is not about the function. It is about access to scarce resources. So really, if that was the approach followed, then a lot of these issues about same service, same rule, etc., would just go away out of the window altogether. Really, all we needed to do was to, as people have pointed out, identify, list those functions, those activities that that the government believes need to be handled differently. But I think abandoning that or not even considering that approach and instead going about having a very generic definition of telecom services is precisely the wrong way to go about it. Yeah.
I'm just going to move to KYC because that's the other crazy sticky point. What kind of privacy issues do we see emerging from this KYC everything on the internet will bring up? Anyone? Okay, just for fun, I'm just going to go right there and ask from folks. So, Aman, I'm going to come in over here because since everyone's moved over here, just curious, in terms of the KYC issue, what kind of privacy issues emerge from that? I'll come to everyone one by one over here.
Sure. Okay, we're coming there. I was just telling Rahul that we should move back, but okay, I'll walk and talk. No, but all sorts, right? If every level of service you're essentially asking to do unequivocal identification, that by itself creates more data than you necessarily need, especially given that at least at some level in this whole chain there is, like even now to get a phone connection you do need to do some amount of KYC, right? So isn't that good enough, right? And it restricts data to one service provider. Why does everybody downstream thereafter need to continue to do that unequivocal identification? It does go against some of the fundamental sort of principles that data protection laws generally talk about.
Okay. Rahul, in terms of, like, how does this play against the Puttaswamy judgment, the need to, the demand to KYC everything online, including on WhatsApp and stuff?
To be really honest, I don't know to what extent the Puttaswamy framework has actually. Yeah. You haven't let me finish my coffee, by the way. So. I'll drop it if I do that.
I'll take it for you.
No.
Go on.
No.
This is light touch regulation.
No, sorry. As regards the Puttaswamy framework, I don't know to what extent it's still. It's to be honest, has it ever really been utilized by anyone anywhere, or it's just a beautiful theoretical thing which has never really happened? That's the first thing. And as regards the KYC bit, I mean, of course, the argument we all made back there was that this KYC actually is a. It sounds very nice, but it's actually a bit of a dangerous thing for this information to be publicly available. But I don't know to what extent this is. I don't know. Actually, I have to think about this. No. Sorry. I meant in terms of what we were looking at KYC at that point in time was in terms of the Aadhaar data. If that data is collected in one central framework, and that was the context in which Puttaswamy dealt with it.
No, actually, I was coming at it from a different perspective, saying that, at one level, you don't want WhatsApp to share its data with Facebook under its new privacy policy. At another level, you want Facebook to get copies of your Aadhaar IDs for using WhatsApp. Like, how does this even work? Sorry, someone has a mic here.
Yes.
I'll come here. Go ahead.
Okay, on KYC, I think my perspective is that if all service providers need to collect information, need to do your KYC before you sign up.
Anything that's a telecommunication service, right? So
from WhatsApp
cloud service
to
providers, WhatsApp, e-commerce services, everyone needs to get copies of Aadhaar. Yes.
That is there, and then on top of that, they have a data localization requirement in case of any sensitive personal data which is being collected under the regulations, right? So now WhatsApp is supposed to collect our KYC data, then store it within India, and then on top of that, there are the powers to the government
slightly
under
different framework to look at it, because the broad definition of telecommunication services, instead of WhatsApp, say Flipkart or say Paytm, because we tend to think of these things with a pure WhatsApp framework, simply because that's the messaging service. But this applies to everything, right?
Yes, of course it does. But my point here is KYC is being collected by all of these organizations under a different regulations, the SPDI regulations. The government requires all this data to be stored locally. And under this bill itself, the government has the power to intercept messages, has the power to take possession of telecom infrastructure. So it effectively, our private data is under a greater threat of privacy from the government itself, right? It's easier for the government to take and intercept KYC data from the organizations because it's being stored locally itself.
From the mobile operators, they can also take, right? So, but is there any precedence globally anywhere on IDing everyone on the internet for every service, in a sense, in a country? So someone had their hand up there, like back there, then here, it's a bit. Short answers, please, right there first. Sorry? Just one sec, while we're coming.
Estonia is one place where every ID is on the internet and everything, all services are linked to it.
And Russia hacked them like a few years ago, right? Yeah. Okay.
Is this on? Yeah. This is where I want to just add another point.
One sec.
Regulation, KYC, security, these are all works in progress at all points in time. There cannot be a legislation which is cast in stone forever. Technology will keep evolving. People will use and misuse. India, unfortunately, is a slightly, I would say, a trustless society.
But there is a question of proportionality, right? And about if you want to talk about pure security, from a issue of surface area of the risk, you then disproportionately increasing.
No, that is not for me, or that is for larger, the government and policymakers and the courts to decide. But this is the reality. That's what I'm. The reality is that as far as why does the government want KYC? Let's go back to the fundamentals. It has to have a track and trace for security purposes. Let's just start from there. I'm not going to look into other things.
Again, question of proportionality, I'll have to go back to Rahul and Puttaswamy on this.
Now that I finished my coffee, my thoughts are better gathered on this. Among the few places where we succeeded completely in the Aadhaar challenge was when the government wanted to link Aadhaar with all buying all SIM cards. They said that was disproportionate. You can't treat everybody as a potential criminal. So you don't need to get to show the Aadhaar to get. You cannot link the Aadhaar with your phone numbers.
57, right?
Yeah. No, that's a different thing. 57 was for private entities which couldn't be done. But that, of course, they changed the law a bit. Then that challenge is still pending. So we don't know what's going to happen to that. No, 56.
Okay, we can't have the 57 discussion right now, but someone has been waiting there for a while. Go ahead.
Hi, Bhavya from the Dialogue. The issues with KYC essentially are that there is no PDP bill in place today. So the balance that is already skewed for data collection companies against a normal citizen gets skewed even more because there are no safeguards for us to, ask for our data back or. Besides this also, the entire bill is against the principles that were under the Puttaswamy judgment, the principles of data retention, purpose limitation, or data provenance for that matter. The bill essentially requires TSPs to collect more and more data that will eventually attract more cyber attacks, or because you're essentially creating a honeypot of data.
I already said that. Yeah. So, Siddharth, back at you. Just a question that I had, I thought I'd ask. I ask you in terms of communication services. Is there so if you remember the SC's comments on the social media monitoring case, the Mohua Moita case, I think, can that be used as a precedence for this requirement to KYC everyone on the internet?
So I think when we think about the KYC provision, it's a good idea to think about how overall it communicates the government of India's overall tone and attitude towards anonymity over the internet as well. It's sort of and you can see this not just in the Telecommunications Bill, but as well as statements before the Joint Parliamentary Committee as well. There was even a department standing committee on external affairs which looked at cybersecurity. And in each juncture, what you see is that the Indian government has a very one-dimensional sort of perspective on anonymity, and which it is that it contributes to cybersecurity and national security risks. So, and I think there's a need for the government of India to sort of try to nuance that idea of anonymity over the internet, because anonymity gives you certain protections, especially for vulnerable and sort of vulnerable users as well as representatives from minority groups. And the idea is that they can selectively disclose parts of their identity to platforms, services, and other users when they interact with one another, because a disclosure of any element of identity can bring value but also carries a certain element of risk. And right now, I think whether it's
who needs third-party cookies anyway now, right?
But the point is that right now, whether it's the Telecom Bill or these other sort of adjacent policy processes as well, I think in general, there needs to be an overall push to nuance the government's attitude to anonymity from both a risk perspective, but also communicate that there are certain individual and community-based rights associated with that concept, and therefore a push towards making all digital services verify people's identity will sort of curtail that right in a thoroughly disproportionate manner. And that needs to be evaluated.
Okay, very quickly, Gangesh and Lloyd. I need to rush because we are running out of time and this stuff to discuss. Go on.
So I'll make two quick points. One is the example. So the anonymity debate was actually has happened many times in the past. In 2007-8, in fact, Korea passed a law with the real name requirement for websites and bloggers, and the idea was to have civil conversations and how comment boards should have real names and stuff like that.
Facebook also had a real name policy which fell flat really quickly, right?
Indeed. So it's failed many times, and I mean I understand there's a distinction between a real name policy and a KYC requirement, but if you're looking at the objective of what they came out with the KYC requirement, the stated objective is that of preventing cyber fraud and the ills of anonymity, like what Siddharth was alluding to. And so you have these failed examples of, and in fact the Korean court also struck this law down. Now the other thing is, if you are, I think when we talked about negotiation strategies in terms of other bills that are coming in, one thing to watch out for is if you are saying, okay, let's exclude OTTs from here, let's exclude the KYC requirement for OTTs from here, what they're going to cram it up into is in the Digital India Act. So this is probably the first sort of move that's being done. So we have to be careful of what we're proposing and what we're holding back on.
Lloyd.
So just a small point, Nikhil. I think it's to contrast the whole KYC debate back in, say, 2008 and 9, when Vikram and I were both on the operator side, when the telecom operators were told that they have to give any new SIM card against an Aadhaar or any identification, any government identification. There was a lot of resistance because that added to the load. One interesting data point, Delhi Airport pre-2008 received an average of 250 to 300 calls a year, bomb hoax calls. 3 years later, when this got fully implemented, that was down to single digit, right? So just as a, for all the other concerns on privacy, there was a great customer convenience. The times you hung out in the airport because there was a bomb hoax call, because somebody from somewhere just picked up a phone and did it. Now, because of the traceability. So there is a little bit of a, a counterpoint that one must keep in mind. Just a point.
I'll just come to Vikram for one last, and this is not, I just want to understand from an operational perspective, the rationale that's given by the minister in terms of KYC is that it will help prevent spam and prevent scams. Telecom is a space where everyone is already KYC'd. Why isn't that preventing scams and spam? What are the challenges that are being
we've
faced
been
by
having
Telecom?
some interesting conversations, and much of it gets driven down from the MHA. So what we've been saying is there are enough laws of the land to catch a guy and, fix that guy who's doing the scam. Or, let's say almost 98% of all KYC is either on Aadhaar or voter ID, right? Aadhaar is available, let's say, biometric. But now there are some socio-economic aspects, when you see places like Jamtara or Mewat. Now, the social conditions are such that, the local young people or the people, fraudsters, have figured out a method to beat the system. And the government is trying to fix that system. In fact, there's one more interesting one they are doing now.
Is this the reason behind voter ID? Sorry, voter ID Aadhaar linkage, is that the reason?
No, one second. So, now what the Department of Telecom is using, they've named it Astra, right? It is a facial recognition thing, where all the photographs that go on your CAF, customer acquisition form for telecom, they're running a face recognition thing and then getting rid of people who've got more than their authorized share of numbers. So, we get these cases have been brought to our notice. एक बार वो चुन्नी ओढ़ के खरीद, लड़की बन के लिपस्टिक लगा के सिम कार्ड ले लिया, एक बार मुंह छुगा के, एक बार दाढ़ी उगा के, एक बार Ram Kumar Ram, and so these are actually challenges that the government is trying to fix, because of late, particularly in COVID times, the amount of financial frauds actually that have gone up are significant and have made the government sit up. So what would be good is to suggest how to improve the KYC rather than, make it more effective.
Sorry, I just noticed something. Are you saying in the facial data that telecom operators are capturing, the government is running facial recognition software?
Yes, they're running that.
Sorry,
and getting rid of.
Did anybody know this?
Next week.
I'm sorry, I'm speechless. You learn something new every day, right? Sorry, go on. I still haven't gotten facial recognition software on the.
So you see it from their point of view. The amount of frauds, of financial frauds that are happening, is the same people using SIM boxes, for example.
Have they issued a notification or anything about this system?
Sorry, Anandman, you want to say something?
No, no.
I. Sorry, everyone okay with extending it a bit more? Okay. I'm getting goosebumps hearing this thing about facial recognition software on the data that telecom operators capture. How is there an authorized? This is becoming a privacy discussion now. It was always a privacy discussion. Okay, let's come back to the point. Who wants to come back to the point?
So
Go
just
ahead.
one thing which I was thinking, that the KYC thing actually does offer another possible ground for challenge legally using Anuradha Bhasin principles, where you can try to argue that this would become a disproportionate restriction on the right to carry out your business or carry out your or even communicate, because your ability to communicate itself also can be, your right to freedom of expression can be clearly argued to be a right to also be anonymous, right? So potentially having a blocker on that.
Do you have a right to be anonymous?
It's arguable that you have that right as part of your right to. It is subject to obviously your national security, public order arguments, but it is arguable within that you do have a certain. Obviously, it's to what degree and then how proportionate is the response. I think that's why it has to be a disproportionality argument. That this would be a disproportional way to address those issues, and would be a violation.
Constitutional lawyer.
There is a right to anonymous speech, and I think that has been recognized by our courts. But again, like Vakasha says, who's also, Vakasha knows so much about this. The fact is that it would depend upon the actual situation. But yes, theoretically, of course, we have a right to anonymous speech.
And it will also depend on which bench hears the matter.
It depends upon the day. It depends on the
Let's
week.
not go into which bench hears what. Anything else on KYC? Anyone have a comment? Any thoughts? Go ahead.
Just one more point on how we are formulating this. So the requirement in the bill is actually that the entity that's granted a license is unequivocally identifying the person to whom it's providing service through a verifiable mode of identification as may be prescribed. So I don't know if we're necessarily centering the discussion as to a KYC in the manner in which we understand it today.
No, it'll just be facial recognition.
Yeah, of course. But in terms of, how as to what the prescribed mode would be, for example, for somebody who is a traditional telco like an Airtel or a Vodafone versus say a OTT provider, the standard of verification that may be expected of one may not be of the other. And when you were also mentioning say Flipkart or Amazon or somebody like that, for example, all these accounts already, for example, require you to have a phone number that's linked to your account. So that's some degree of verification that's already happening. So for example, is it enough for Flipkart to say that, okay, this account belongs to a person holding so-and-so phone number, and then can be reached out to so-and-so
Right, so there's the backward traceability is always there, but like I said earlier, none of this is reducing spam and scams anyway.
Right, absolutely. But it's just in terms of how we
any thoughts on KYC?
I know you have a mask on, but
try. No, I think I was actually thinking on similar lines as the gentleman up ahead was talking about KYC. I'm also curious to understand the intent behind the KYC piece outside of
Facial recognition.
I think we're all a little bit thrown off.
Stop with this,
Yeah, I think we're all a little bit thrown off on this one. But no, I think I don't have anything incremental on KYC. I would have a question that the degree of KYC, would that differ based on the kind of service being provided? And then therefore, in every single question that we're talking about, are we effectively talking about the fragmentation of the internet and slicing and dicing of services provided on the internet with differential regulation applying to different kinds of services? For instance, for someone who's shopping on an e-commerce website versus someone who's watching content versus someone who's quote-unquote communicating interpersonally, are there differential degrees of KYC required? And that question then kind of applies to across the bill itself, right? Are there differential degrees of regulation required? And then if the answer to that is yes, are we principally accepting a future where there is fragmentation of the internet effectively, and that's kind of where we're going?
So I have a lot of questions on jurisdiction and sort of conflicts between ministries, because hold on for a second. Because the way I'm thinking about it is that in this is sort of the DOT's way of usurping everyone else's domain in a sense, right? If you think about it, because otherwise, what did you have? You had MIB looking at streaming, potentially MIB in the future looking at gaming, whereas it had literally no role in the digital space before the IT rules. Matey, it seems, doesn't want anything to do with anything, so it's saying, you take this, you take that. Every ministry is getting their own fair share. DPIIT is looking at e-commerce regulation. But with this, all of this comes to the DOT, right? I'm just curious about, does anyone else see any other overlaps, and will other ministries even allow this to happen?
Yeah, I mean, I think that is the question ultimately, isn't it? In terms of how the regulation is ultimately going to pan out, and which is why we're having all these conversations on definitional clarity, etc. See, think about I think 8 years ago, when in 2014, when we had the new government, the first order of business by the government, or one of the first orders of business of the government, was to merge the Ministry of Tech and Telecom under one single ministry and have them as two distinct departments. A couple of years down the line, we went back into having two separate ministries as opposed to just two administrative departments. There's a separate communications ministry, separate IT ministry, right? The purpose of a lot of the discussion around distinction of powers and I'm speaking purely as a lawyer on this one, just taking off any other professional hats. But the purpose of the distinction between of powers is the principle of checks and balances, right? Now, with that background and context in place, every time we start a discussion around a super regulatory structure, I think that conversation gets eroded a little bit on the checks and balances and the difference of structures and balance of powers, etc., etc. The constitutional basis of lawmaking and law enactment in that sense. So I think the one thing that I'm most curious about under the Telecom Bill is how is it ultimately going to pan out? Are we now talking about whether we call it the Telecom Ministry or ultimately call it the Communications Ministry or call it a communications regulator or whatever it is? Is it one single internet regulator that we're talking about?
Internet and telecom regulator then, no?
Effectively, yes. So then it's content plus carriage in that sense, right? So, and if we are distinguishing content and carriage, is that one singular regulator the expert in that sense to be the correct regulator for all of it? Or then, like I said, are we just talking about fragmentation of the internet in terms of regulatory structures? At this point, we're looking at one single IT Act that governs everything on the internet, and then there is sectoral regulation for things like payments, for things like now streaming or whatever else. And those are very specific aspects. It doesn't cover the access to those services. It covers regulatory aspects of those services. Now we seem to be going one step deeper and talking about access to those services as well, either being bunched up together and being regulated as one telecom service, or being fragmented, broken down into different pieces of the internet. I'm not sure which is the approach. I'm not sure which is the approach. As a consumer, I think my interest as a consumer at all points in time would be ease of access, low prices, seamless access to the internet and services, safe access to the internet and services, etc., etc. So I think as a consumer, my interest will continue to stay the same. I'm yet to understand how the Telecom Bill solves for or incrementally solves for consumer concerns.
It actually leads to an increase in cost for everyone because you have a regulatory
licensing
cost,
everything, yeah,
or a registration or licensing of everything adds to that cost of operations.
Yeah, so which is why I think that's my question as a consumer as to what is the benefit that is being brought to me by a new regulation that effectively increases the ability of everyone on the internet to provide access to.
We got regulated under the IT rules. It added cost and more than that, a lot of procedural unnecessary headaches for the news industry. But so I don't see how it helps anyone. You've been waiting.
I was only on the point of the KYC thing that you were talking about earlier.
We can still talk about
so
the
you want to go back on that?
We can still talk about KYC. Would you like to do facial recognition? Sorry.
Sorry. Okay, no. I was only on the point of that definition that you're talking about, which led to the discussion on KYC. My interpretation of that clause was not just about it being about KYC. It was much more larger than that. The entire intent of that clause, I think, was to hit upon this whole issue of kind of trying to control the encryption privacy issue that we have been talking about in terms of revealing of identities of senders.
We
identities.
still have to talk about lawful interception, yes.
Yeah, so no, this is related to that, and that was my reading of this clause. That is, KYC is just a small part of it. What you have to understand is the larger game behind this entire bill, so to say. And clause by clause, of course, we are discussing, and I think we are on the same point, almost, nuances apart, that there is a big problem with this entire bill right from the definition downwards. Okay, now the entire intent of this bill is pretty clear to everyone in this room.
Amitabh,
right?
you've seen regulatory structures, regulators evolve over a period of time. How have you seen TRAI's role change, and what does this bill do to the TRAI?
Exactly. So I was around since the time of 94 NTP, right? And I was one of the 5 companies who took that email license.
You ran an ISP at that time.
I was working with GTL, which was an email service provider, and I signed those licenses. And
With an email service provider
yes.
that had a license?
Yeah.
Wow.
That was
okay.
when value-added services were opened, pursuant to NTP 94, and which was the first step towards liberalization of telecom. And I think, so there's a lot of history behind that, and I can talk at length about exactly what happened at every step, year by year, month by month, So we are these 4-5 service providers who were the email service providers, and we actually did fight to open up internet. And I actually ended up spearheading this entire ISP industry, enrolling them right to the, I actually intervened and helped to get the licenses written down. And there was a point where I took them to court, which was the court that we went to when we did not like the ISP policy that came out in January 98, the initial one, was TRAI. TRAI at that point of time had adjudicatory powers. It was a constitutional body. So this was the actual TRAI in 1997. Unfortunately, between 97 and 2000, government, as a service provider and as a regulator at that point of time, did not really like the idea of the regulator being very, very proactive in terms of judgments and orders, which were largely directed against the interests of the monopolies, which were government monopolies, number one. Number two, I think at that point of time, the telecom industry itself was going through a lot of crisis because of the high prices that they had bid for in 94, 95. And they were looking for a way out, and I think there was an issue with some of these operators who also wanted TRAI's powers curtailed, and which is the reason why TRAI 2000 amendment came in, and the adjudicatory power was taken away from TRAI.
Okay.
So I was one of those who didn't really like that idea. I thought they were doing a fantastic job, and this bill actually seeks to overturn the entire 28 years of development of telecom industry in terms of trying to move it towards deregulation.
Sorry.
So, I mean, to me, the first thing that hit me was this goes against the very principle of an independent regulatory system that we brought in, where an expert body like a TRAI, there could be some decisions that you can always be criticizing TRAI for, but mostly they've done a good job of deregulating the entire industry from 97 onwards. Look at the tariff work that they've done, look at the interconnection work that they've done, look at the kind of work that they've done on all the spheres, quality of service, regulation. So many things that they've done have been hugely impactful positively for the industry, and that's the reason why we had investments coming into the industry, because we had an independent regulator. Now, what you're essentially doing with this telecom bill is saying that, okay, we go back to pre-94 days and saying, okay, we will, as a central government, decide everything. Now, there's a principal issue here, and the issue is central government itself is a large stakeholder in the telecom industry. Right? As a large stakeholder in the telecom industry, I am going to sit down and write a telecom bill. And
you're saying there's a conflict of interest?
There's a huge conflict of interest. I mean, there's a biased interest in suggesting in the bill that all the powers have to lie with me. I am a regulator, I am a service provider, and I am the lawmaker, all roll into one. And this is again back to pre-94 days. So you're turning back telecom's history of development in India 28 years back. Now that's something that I think I will not go into the details of how challengeable it is judicially, constitutionally, but it is certainly challengeable in the courts of law, whether one can go to TDSAT or whether you can go, you go to the High Court to begin with, and then start challenging the provisions of this bill and the intent of the bill. clause by clause. There could be so many clauses you may not agree within yourselves, but that's part of the argument that you structure, right? I've been party to many of these court cases since 90s, where we took DOT to court with their knowledge, of course. We went to TRI lost its powers, we went to the other courts, to TDSAT, and we did have a winning case most of the time.
Yeah, but you can't always keep litigating your way towards
No, but then,
regulatory
okay, so
change,
let me answer this. Initially, there was some discussion about negotiation. Now, this bill is not drafted, and the conditions, so to say, the political conditions are not conducive enough to have serious negotiations. It's basically a top-down approach right now that you are looking at. So idea here is not that kind of, see, there was a difference between the governments earlier, where they would invite the people and the stakeholders from the industry, have discussions across the table, and take policy decisions. When they could not, they knew that we would go to court. And I think our industry, the internet industry and the telecom industry, has been famous for litigations. Okay, but most of the time, the litigations that we did.
Internet industry that much.
What you're fighting for is the future of this telecom industry, not as just telecom industry, but also encompassing internet, OTT, right to, so many rights that are going to be violated, and it'll be in the hands of the central government. And you know what used to happen earlier, pre-90s.
I don't.
You don't. So that's where people like, I don't know, Mr. Upal, he was there with us through most of the journey, and he's seen how we have evolved. We had to fight every step of the way. And even for the internet policy, I took them to court. We won. Okay, and there are courts which will listen to your arguments if they're, cogent and tangible. One thing that you cannot argue is in the courts, going by so many judgments in the high courts, is the power of the government to make the law. Interpretation of the law is what you can challenge them on. And how they're interpreting this, these clauses of the bill is what, and as a law graduate also I can say that.
We've seen laws challenged as well.
No, that's a later stage. But today what you have to challenge is on the merits of the contents of the bill itself. Now, unless you do that, you will probably not have a case. You'll end up with a bill as an act.
So there's a point right at the back.
Just adding to the question, to the topic on challenge to litigation, in the current bill, there are so many provisions which are open-ended, such as the licensing framework itself, or there are provisions like on default, the exemptions that can be given, or waivers that can be given in case of default of payment, etc. However, all these provisions are very broadly worded, and they don't lay down the qualifying or disqualifying criteria. So another question that I have is, do these set of provisions make room for a case of excessive delegation, because there is no qualifying criteria at all for the rulemaking authority?
Anyone? You want to take that? Okay. Rahul also wants to come in, but go ahead, Jalal.
So I think we've been talking about this, and one of the concerns is.
Do you want to respond to that?
Sorry, no.
Okay, Rahul.
Firstly, it's a bit depressing not to be talking about litigating a challenge when you're actually talking about the terms of the law, but I suppose that's where we are now. But you are absolutely right that excessive delegation is definitely a point over here. If there is, the law is that if there is any delegation, there has to be certain governing principles contained in the law or the section itself. So where it is as broad as this, and you can do whatever you feel like, I think it's definitely a solid ground for challenge will be that this would be excessively delegated. So whatever the regulator decides, if they decide tomorrow to do X versus Y, and there is no principle which can be identified from the law, then that can certainly be challenged.
Sorry, I'll just go.
See, last couple of years, I've actually spent a lot of time studying a lot of telecom acts and rules and regulations and the policies of various countries. And I can take the specific examples of some of these neighboring countries. When you look at their telecom bills, so Deepak earlier mentioned about there being the same Telegraph Act from the British colonial times, but not only that, my point is different. All these acts that other countries have adopted, and I'm not talking about non-democratic countries, right, or non-liberalized economies, they start with defining the role of a regulator, which is an independent regulator. this is what this bill misses out on. I mean, to make that earlier point and buttress that point, that this is an intent to destroy independent regulation. So I think that's also one of the reasons to challenge it.
So I'm going to go there and Zalak's been waiting for a while. I'll come to you.
Just to quickly add to the excessive delegation point, the KYC norms, as she mentioned, there can be different level of KYC norm which the government would want to prescribe. But the Act itself has no policy which says what kind of norm should be followed for a particular sort of service you are trying to get the KYC for. And even the civil liabilities have been completely given off to the government, so they can describe what a civil liability is, the definition part of it, and compensation and penalty part of it. So you don't find any sort of policy within the Act which has been delegated.
So, on regulatory overlap, I mean, there is obviously a lot of regulatory overlap.
Can't you have to hold the mic up and speak up a bit?
So on regulatory overlap, of course, there's a lot of regulatory overlap, right? There's with TRI, with a potential data protection authority, whatever
With
shape
MATI, with MIT, with DPIIT.
Yeah, right. And that, of course, raises many different concerns, right? There's regulatory uncertainty, which is not good for industry. It's not good for consumers. There's scope for regulatory arbitrage, which again is, not good for governments, not good for consumers, not good for, industry players creating a level playing field. And I think, the biggest concern is we haven't sort of settled on the shape and format of our data protection law. And in this bill, I think we will end up hard coding a lot of things that have implications on how that can be framed and whether we can frame a strong data protection
For example?
law. You want to talk to that?
As in, so I guess the question of exemptions under the data protection law bill that we've seen so far is a conversation by itself. But for example, when you look at the interception requirements under the Telecom bill, if you look at what we've been talking about in terms of KYC and the general traceability conversation, when you're creating a regulatory framework that is setting context for where these measures are permitted, these tend to be seen as more reasonable incursions into the right to privacy more generally, and is likely what you will see in a data protection regulation. Now, obviously, we can have conversations about whether or not restrictions on the right to privacy are proportionate, but ideally, you would have an enabling data protection law in place before then you start debating the extent to which you would infringe on those rights with various regulations, right?
Or you would infringe first and then decide what the data protection law should.
I mean, whether or not it's an infringement should
enable in the
ideally
past,
flow
right?
from your data protection law, which doesn't exist in this case.
I guess we decide first principles before we decide the exceptions, but yeah, I think we all know where we're headed, so it's not a big surprise. But yeah, I mean, in terms of framing regulation, you set a baseline and then you figure out what you carve out. Over here, we're carving out before we've really decided on the baseline, which is
So,
hugely problematic.
I have one really interesting question on this. Shubhang, if he's around here, I don't know. Okay. Had a question on granting the TRAI powers to regulate predatory pricing raises questions about jurisdictional overlaps between TRAI and CCI. We've had that fight before, right? Should the TRAI have the power to regulate anti-competitive practices, or should that be left to the CCI? What jurisprudence does the TRAI have to rely upon while adjudicating on any such matters? In case it relied on competition law jurisprudence, is it not appropriate to leave it to the CCI? Anyone with a competition law view? There you go. It's on.
Okay. So just to clarify on the question, TRAI always had the power to check predatory pricing as part of its TTOs. Under Section 11 of the TRAI Act, there are three areas where TRAI has absolute powers. That is QoS, that is quality of service, tariff, and interconnection.
But the problem is, if you go back to definitions, then the TRAI gets all of these powers over the entire internet.
Let's stick to tariff for this question, and then we can take on
tariff for anything. Like
tariff or
how much
telecommunication?
Amazon is charging its suppliers for hosting products on Amazon.com?
No.
That's it.
Okay.
Because just by definition, it extends to everything, right? The TRAI then will cover, the DOT and TRAI will cover all sectors of the internet, not just telecom.
Okay, so that's a separate conversation. But on this particular question, if we can keep the answer simplistic, so TRAI, under the TRAI Act, let's not talk about the Telecom Bill for a minute. Under the TRAI Act, they have absolute powers to regulate, not to recommend, regulate tariff, quality of service and interconnection for telecom service providers. Now the definition of telecommunication services and telecom service providers is what is being debated right now. So we'll take it later. But on tariff, let's come back to it. So under section 11(1)(a), that is wherein you get the powers to regulate tariff, for TTOs, that tariff orders, there are 4 basic principles on, even though tariff is under forbearance in India, forbearance meaning the telecom operators can actually decide how they want to price their tariff packs, but there are 4 basic principles on which each tariff plan should be there. So one is transparency, non-discriminatory, and non-predation is also one of the principles. And how you used to decide non-predation was that there, in fact, you must be aware that there was this whole conversation around floor pricing, that whether there should be floor pricing in telecom or not, and then eventually it was decided not to keep one. But IUC compliance, that is the minimum charges that are exchanged between the operators, tariff should not be below that. Now, we are anyway in bill and keep regime, so there is no IUC that is exchanged between the operators. But that being said, tariff was always non-predatory and that power was always with TRAI. So I'm not talking about all the other amendments that have been suggested, but for this one particular amendment, I think TRAI always had this power. And just because it is mentioned under section 11, it should not make a lot of difference.
Right, except that it shouldn't extend to the internet.
So that's what I'm saying. The definition of telecom services or telecommunication services is a separate matter altogether.
Okay. There's another question on the impact of this regulation with the certain cybersecurity regulations. Anyone have a view on that?
Hi, this is Astha from Ikigai Law. One definite overlap that I can probably see is on the KYC bit. Like the certain norms also require not really to conduct KYC but store KYC related data, and VDA, the virtual asset providers and other service providers are required to do that. Now the Telecom Bill says that you need to conduct KYC. What on this specific aspect, what I feel like where certain rules may be justified, but Telecom Bill may be not, is that we have to see why KYC is required. So when we talk about financial services, right, there's this whole AML, CFT concern, and because of that, you need to conduct KYC. But for example, to purchase goods from Amazon, Flipkart, to simply message someone, why do you need to conduct KYC? So that why needs to be answered before probably the rules under this are framed. And this is one specific comment that should probably go to the government, asking why do you need a telecom service provider, basically whoever is covered under definition, to conduct KYC, and if you do, how will that KYC be graded? Will it be equivalent to the KYC that a financial service provider does under the KYC master directions that RBI prescribed, which is so onerous as a requirement, right? Or will it be light touch, like just collecting just OTP based KYC, right? So that gradation is very, very important. I feel it will differ based on the type of telecom services you provide.
Facial recognition.
I have no comments on that. But I do feel like, KYC is one issue that, at least as a financial services lawyer, I see persistently cropping up. In some cases, it makes sense. When we talk about cryptocurrency transactions and anonymity, it makes sense. When we talk about financial services, it makes sense. But when I talk about buying goods from Amazon or messaging Nikhil tomorrow, do you really need to conduct my KYC before I do that? I find that absurd. So that's number one. Number two, in some cases, you'll actually need anonymity on internet. And a beautiful example is CBDC and the concept note that got released last week, right? And there the government says how it wants to make CBDC equivalent, or it wants to know some parallel between CBDC and cash, because that's how people will use CBDC, right? Like if I'm making payment to somebody tomorrow, I don't want every small bit to be traced. Now, to ensure that anonymity, you need to go back to the Telecom Bill type of laws and see how anonymity on internet in general will be ensured. And then you need to come to specific use cases like CBDC. So if you need me to conduct KYC for each and everything, how will you solve the conflicts like ensuring anonymity when you're giving access to CBDC? So those are the questions which are very complicated, right? And they need to be answered before a generic rule like this is implemented. So those were the two bits I wanted to add. Thank you.
So I think we'll talk about lawful interception now, and now that Aditi is here, she'll take over from me on the lawful interception portion. I'm kidding. Come. Go ahead, come. Yes, come. I'm serious.
Hi, for people who don't know, I'm Aditi. I worked at Media Nama and now I'm at News Laundry. So vis-a-vis lawful interception, what are your takes on the Telecom Bill and how it goes about it? Because it seems to me it appeared after talking to a whole bunch of lawyers that it's just given carte blanche to the government to basically intercept any call. And how does that interact with the Telegraph Act notification that came out in December 2019, which only empowered 10 organizations under the government to do that? Oh, sorry.
Anyone? Sorry, Aditi, you're such a good sport. I just threw her under the bus right now over here.
I hope I survived.
Yeah. Anyone on lawful interception?
I mean, and I think this may depend on what sort of rules get framed here, because the meat of the lawful interception, to my mind, is still 419A of the Telegraph rules, which sort of copies the PUCL judgment. And that's actually been, to some extent, been replicated in the IT rules as well. So the language in the current version, to my mind, is not very dissimilar as against the old 5.2 of the Telegraph Act, that national security, emergency, you can do interception, monitoring and all that.
But then, you're extending that to everything online now, and pretty much everything under the sun. So the scale of lawful interception, like if you look at the way the centralized monitoring system operates, if you want to just if you see how the centralized monitoring system operates, that basically fits into your telecom networks and surveils everything. And I think Saikat was supposed to be here, but Saikat had done a story, he's talked about it quite a bit, that the people who are reviewing those orders are reviewing 300 orders a day. So the scale at which those orders are being passed is substantive. So there's no possibility of an rational application of mind to that number of orders. You increase that to internet scale. How does this even stand?
Yeah, I mean, one argument is that there is already the same regulation on internet, because the IT interception rules actually say the same thing when it comes to procedure, pretty much the same thing. So, and that applies to any owner of any computer records wherever it's situated. So I guess the issue is that will the new rules actually import the PUCL restrictions into the new telecom draft bill, or will they just create a super highway for interception orders?
I think in general, to answer your question about what we've been thinking about the interception provisions, I think you're right that given the definition of telecommunication services and telecommunication networks, that it does cover basically all communication that happens online, including things like machine-to-machine communication. So in theory, you could also order that IoT devices and the messages from IoT devices, or data from IoT devices is also provided and intercepted to the government, right? So this is obviously broadening the scope of the Telegraph Act. You can argue that again, all of this is covered under the definition of a telegraph, but here you're very explicitly broadening the definition to include a wider range of communications. So I know we've spoken about the PUCL judgment, and those safeguards aren't at least right now instituted in the Act itself. And again, I think you can have a conversation about delegated legislation and whether or not you should at least indicate that those safeguards should exist in the parent Act. But also since PUCL, we've had Puttaswamy and we've had Aadhaar, and so we have a 4-pronged test, of which proportionality and procedural safeguards are parts of the 4-pronged test. So essentially allowing interception without safeguards of all kinds of communication that happens online would be, in our view, or my view, a disproportionate infringement on the right to privacy that Puttaswamy reaffirms, right? And when you talk about the procedural safeguards that PUCL also incorporates, we've seen, for example, that it doesn't really work. So I think in response to some RTI requests, and I think in Parliament, the government basically said that the review committee that meets once in 2 months, in theory would be approving or like examining whether or not about 15 to 18,000 interception requests in each meeting, whether or not they were valid. So this obviously doesn't work as an oversight mechanism. And so I think, and whoever spoke earlier was right that some of this is reflected in the IT Act as well. So this points more to like the need for an overall interception reform. We do need to make sure that they're harmonized, and we do need to make sure that we revisit whether or not these safeguards that we have in place right now comply with the requirements for under Puttaswamy and Aadhaar, and also whether or not we need to incorporate safeguards like, for example, an independent oversight process, which in most other jurisdictions tends to be like a judicial oversight.
Do you think that this has anything to do with the challenge to the interception challenge to the IT rules that WhatsApp has mounted?
Does it have anything to do with
the inclusion of the expansion of interception to everything? Does it have to, because then you have legislative sanction at some level?
I mean, in theory, you would have the same challenge with this bill if it gets passed also, right? I mean, the fact that you have a law that authorizes it doesn't mean that the law is valid and is not open to constitutional challenge.
Okay, there's a point there then here.
I think in furtherance of what has already been said, in relation to interception, the grounds of interception have been barely mentioned under the bill by saying public emergency, public safety, public order, but what actually constitutes public emergency or public safety, public order has not been defined, and it has been left up to the interpretation of the government. And what we can see, like, considering interception of communication and communication channels leads to a restriction on the right to free speech and privacy, these kind of terms and grounds on which this kind of interception is done cannot be left to the whims of the government and have to be concretized and properly defined under the bill itself, because otherwise the government is free to interpret it in whatever way they want, and as has been said, you then can't check the proportionality of it, the reasonableness of it, which are the basic grounds of any kind of restriction of fundamental rights.
Okay, for Rahul and Anirban, and I just wanted to also read out something related to shutdown and a surveillance aspect to it. We'll get to that next.
Quickly, I think in some way this is actually a positive step, because if you think before this, even the first step of Puttaswamy, that is the legality requirement, wasn't met. What is the legal framework for CMS, for example? Or there was something which I read about called Atma, which appeared in some newspaper headlines in 2018, then disappeared. So the various surveillance mechanisms now, apart from whatever happens under the blocking rules, are completely under the radar. So at least if this comes over here, this can be now frontally challenged. Right now, as far as I understand, this unlawful surveillance is under challenge in a case called Center for Public Interest Litigation in the Delhi High Court. I don't know what's happening to that case. It was filed some time back. But at least now there'll be a solid basis for it. And then again, I mean, everybody's been talking about the grounds of proportionality. Of course, all of that will exist and all the old precedents will apply. But I think the fact that it is now at least been laid down is definitely a positive step. Until now, what is the legal framework for our surveillance laws? There's pretty much nothing.
And I think Jalak wanted to add something to this before we come to you. Okay, so Jalak, Vakasha.
Just quickly, Rahul, I'm not sure if...
mic up, please.
I'm not sure if the Telecom draft bill will apply to something like CMS, right? Because it's still talking about, from my understanding, particular interception. The nature of CMS is more in the nature of mass surveillance. So I'm not, like, I don't know if what your reading is, but I'm not certain that this would really bring something like CMS into the play.
My understanding of CMS is that it's a system that exists in the telecom networks that allows the government to surveil whatever they want, when they want, but those are still individual surveillance orders that come in and not surveilling all activity on the network. So it is happening at a large scale, but it's still not surveilling everything.
I had a more subtle point about this actually.
Yeah.
The fact is that if this exists, then that part should not exist. You know what I'm trying to say? That the legal requirement then would be this and not that. So either this gets covered by it, or it gets excluded by it.
I didn't understand all.
I'm sorry, it's a slightly complicated argument. I don't know if it works or not, but the way I was thinking about it is that the law permits you to surveillance is something which for which a law is needed. So if that is what the law permits, that is this, then other stuff you are not automatically excluded from doing.
Okay, interesting. Okay.
So one thing which I was thinking is that one amendment which needs to be suggested is that we have to, I think, mention also what are the methods and the tools used to intercept, right? Currently, it allows that broad power which has been then used to use things like whether it's malware services, whether it is your Pegasus kind of things, which currently the problem is there's no ruling which even says that those are incorrect, right? Or there's no restriction on the tools you can use to intercept. So even so they amount to hacking and greater levels of surveillance than even per se are foreseen. So I think it would also be worth us suggesting at least an amendment to clarify the kind of tools which can be used for interception. I mean, this is obviously worst case scenario where nothing else is being accepted. Other things where
seriously?
But I'm just saying that is the kind of thing we do need to kind of also keep in mind, that if they do push this through, we don't want them to then have carte blanche on what they can use, which I mean, in a sense they will, but at least we want to have some opportunity to challenge that, because otherwise, because this is the big failing of the Pegasus judgment, right? They didn't pick that issue up at all, that what are the acceptable tools for this, and I think that needs to be specified perhaps in this or mentioned as an area which has to be picked up. At least we need to put that out there.
Subordinate legislation that will list the software that you can use to do surveillance.
I mean, the thing is, it's not about the list of software itself, but the characteristics of what you're doing, right? So essentially defining what are, because your Section 43 IT Act is still there, right? It's still there saying you cannot, like, nobody can hack, and that's not even the government can hack, right? So the question is there a way where you incorporate that here to bring in a little bit more of an ability to challenge the ways in which they can intercept things? I think that's something which needs to be thought about as well.
Understood. Related point?
No, unrelated. Next topic.
Next. I had something on the shutdown rule. Sorry, there's a point right at the back. Aditi, yeah.
My point on this whole hacking issue and my point on the whole hacking and interception issue is that I'm just going through the Telecom bill, and it says direct that any message or class of messages to or from any person or class of persons or relating to any particular subject brought for transmission by or transmitted or received by any telecommunication services or telecommunication network shall not be transmitted or shall be intercepted and or detained or disclosed to the officer. So who's doing this disclosing? And from the reading of this,
this is from the shutdown part of it, or is the other part of it? I was just about to read that actually. Yeah.
Yeah. So in this one, who is doing the disclosures? Who's doing the interception? That actually seems to be the telecommunication service provider or the network. So, Vakasha, I don't know if the tools need to be specified or the principles around such tools need to be specified. And even with the Pegasus judgment, that was one of the most important points. That one of the reasons the government did not take any responsibility or acknowledge in any way that they had used Pegasus, because then they would have been guilty and Section 43 of the IT Act would have been applied on them. So,
that's kind of the point, that because, I mean, look, it being very realistic, even if you did include a protection in the judgment, if they wanted to use something else, they will, right? Let's not pretend that that's not going to happen. But it's in terms of trying to layer in some safeguards, we have to talk about that, because yes, as you're saying, part of it, the disclosure requirement is coming from the government. But like, since we are going to be talking about interception of communications in the same way that 69 allows for it, right? That's where this comes in. That 69, for instance, doesn't have any restrictions on what the mode is going to be. It just says can intercept, decrypt, I think what are the three terms it uses.
Yeah.
So that language where it's reflected in this, which I think it's 24, is it 24.2? I think, I'm not sure, which
This is
allows that.
24.2.
Yeah, so that can still, I think, that still does, I think, work for what the government can ask for as well, right? Because otherwise that's where the power to, where is the power to exercise the surveillance comes from 69, right?
Yeah, but here, I mean, someone else also mentioned it.
Mic up, please.
Sorry?
Can't hear you.
Yeah, sorry. Someone else also mentioned it that the reasons given for allowing such interception are fairly broad. There are the 19 exceptions, public emergency, public order, public safety, all of that. I vaguely remember this judgment which had those circles of public emergencies and public orders, the three concentric circles. I'm sorry, lawyers probably know it better.
I mean, that's your...
Go on. There's a mic right next to you. Go on. Was it Shreya Singhal?
No. Was it no?
Loya
it was an
downwards.
older-
Na Ramanor, Loya 2, and then recognized again in Anuradha Bhasin, made that distinction.
Yes, I think it was cited in the Anuradha Bhasin
Exactly,
judgment, the
yeah,
three
yeah.
concentric circles.
So, no, all I'm saying is that's there in these things, but that we've seen the public order stuff constantly ignored in terms of how you actually use it, right? So, I mean, maybe it's a point which doesn't have to get put in. I'm just trying to think that if we are trying to deal with a question of a power of interception, we have to also think about something which is the way in which that happens.
It's not just, right? If you look at this particular clause, it also says that directed communications, a class of communications to or from any person or class of persons or relating to any particular subject, which basically means you're surveilling all the text on the network to prevent a subject
on
matter,
keyword basis.
keyword basis or something prevented from going on the network. Neatly.
Yeah, so 2 points. I think I haven't heard anyone, mention encryption or, end-to-end encrypted communications yet. What is this going to mean for end-to-end encrypted messaging platforms in particular? So this basically means that E2E platforms just cannot offer services in India any longer. And, if they're trying to bundle up all of the litigation that they're seeing in various courts, and, now it's in front of the Supreme Court, and trying to squash that under this particular act, does that then mean that they're asking for lawful access, because that argument had fallen flat many years ago? Are they asking for traceability to be implemented in this manner? What are they asking? Because I don't think any end-to-end encrypted messaging service is willing to dilute security for users across the world just for the Indian market. That's my first point. The second point is the sort of privacy security.
Just on that point,
Yeah.
Neeti, I think at some level the problem starts with Australia, right? And that's being seen as, if it's possible to do it in Australia, then why can't we do it elsewhere? Kind of a situation. Okay, go on. On this point? Sorry, I'll just come back to you.
Yes, is this on? Yeah. So I think on the encryption point, one thing that has been slightly under discussed is if OTT communication services fall within a licensing regime. One of the things that we need to keep in mind is that if similar standards are transposed from TSPs and ISPs to OTT communication services, and specifically like WhatsApp and Signal, we need to keep in mind that there are like sort of upper limit thresholds on the strength of the encryption that TSPs can deploy under the licensing regime. So one point is that in certain like international long distance sort of licensing provisions, there are like sort of caps on like, and these are really old provisions, legacy provisions, but there are caps on like encryption can't be more than 40 bits in terms of keystroke length. And also there are explicit provisions within the unified licensing framework that an undefined term, bulk encryption, is not allowed for TSPs and ISPs. So if you're trying, the risk is that when you bundle a bunch of services under the common umbrella of telecommunication services, then the same standards could be applied across the board. So we just need to like sort of make a concerted sort of argument or representation to the government that there are not only privacy risks when you create upper limit thresholds to encryption, but there are also cybersecurity risks. Because the fact is that there are sophisticated state and non-state actors that are always looking for vulnerabilities within cyberspace. And So when you're so that kind of risk should also be communicated in your sort of consultation responses, that there are like security risks attached with encryption standards as well, as over and above the privacy and interception and monitoring risks as well.
Yeah, completely agree. Just my last couple of points about one's on encryption. So, if as you said, Nikhil, if they're trying to find any material related to a particular subject, they're essentially asking for all sorts of content moderation, right? But they haven't exactly specified how. How is this content going to be moderated? Is there a grandfathering clause? Are all service providers going to look at all the data retrospectively shared on their platforms and then prospectively as well? And this is a massive amount of data to be scanned. That's my first point, also related to encryption. And my last point is just about, are you then asking networks which are data agnostic to then moderate content? Because then that
What do you mean data agnostic?
they basically shouldn't and don't care about the sort of data that's transmitting through their networks.
What effect does this have on safe harbor?
Intermediary liability, of course it does. Yes, 100% it does. It's going to hold platforms, but that's a smaller concern I have. My bigger concern is then you're interfering and you're disrupting the whole architecture of the internet. Right? Because right now we're still concerned with the content layer of the internet. Once we start going into the, messing with the data agnostic nature of networks, then you're messing with the network layer of the internet, which is going to be so much more expensive, and it's going to be so disruptive that networks are going to find it extremely hard and expensive to interoperate with one another. And this is just within the country. When we talk about India and other countries, it's going to be a completely different mess. And then on the safe harbor provisions, the intermediary liability provisions, we're already seeing, numerous governments trying to debate that, whether platforms are responsible.
I'll add another thing to the mix.
Yeah.
When you look at the internet shutdown provisions, it includes, apart from surveilling all content that the government may direct or a particular officer might direct, you also have to ensure preventing incitement to an offense. That I'm not sure how anyone can even figure out.
Yeah, this bill, especially chapter 6, where they're talking about public safety, national security, it's amazing. Like, it's amazing how broad this is and how anyone who was publishing this thought this was a good idea.
I think we're going to close soon, but any last comments? Go on. You've been waiting for a really long time. Sorry, Anirban.
No, I think, can you hear me? Yeah. So this probably builds up on a lot of what was discussed.
Just before, there are tea and snacks are going to be, so hang on and love to catch up with folks. Sorry, Anirban.
So, I'm going with the public interest aspect of this, and I'm also, apart from being a lawyer, bit of a technophile. So I have a bunch of Internet of Things devices running in my house. They talk to Chinese, American, and Swedish servers. None of them are willing to come to India to register. They don't really care, but I am interested in utilizing their services. So as a consumer, if tomorrow they are compelled to register and they don't come, I lose out on the services. So I wonder how many of such services are being used by Indian citizens, and whether these foreign companies will ever come and listen to India. As an example, today I can't use my credit card to buy a magazine subscription online abroad because it no longer works. They will not conform to the Indian standards because they are not Netflix or Amazon. I'm just a small footprint. Now, if this rationale starts getting applied everywhere, not only is it a balkanization of internet, but like she said, the entire services would get disrupted and fragmented. And I don't think a litigation is the real answer to solve this.
We are discussing interception surveillance, but we have not discussed yet the judicial oversight part over the surveillance and interception. And I believe that after Puttaswamy has transformed the whole landscape of privacy, and it's a wonderful time to give some legal sanctity to judicial oversight under the bill. And apart from that, I'm not sure whether it's feasible to codify the proportionality standard under the bill, because we cannot include everything. Since interception is invading privacy, it must satisfy proportionality standard, and we should codify that standard under this bill.
Any last comments, anyone? Sneha.
Just a couple of points on
Just before anyone else, we'll just quickly wrap up. Okay, final comment.
something completely different. I don't think related to interception only. I think the way I was reading clause 24(1)(a) was mostly on when you talk about mass surveillance.
What's clause 24?
Sorry, the whole the part about how you have to pass an order to get interception, suspension. Again, let me just open it for my convenience as well.
What is being seen as the shutdown provision, but is in fact
24(2), sorry,
much more than that.
Yeah, and when we're talking about mass surveillance, 2 points that I just wanted to make. One, I think the idea that the government had behind this was simply at the time of a public emergency or at the time of interest, in the interest of public safety, we want to know what is trending. That's what my first thought was when I read that particular clause or that particular language. Second was, can an argument be made that if an order of such nature is passed where the government wants to know what is trending in relation to a subject during the time of a public emergency or in the interest of public safety, it's only the message and not the messenger, as in the person who put up the message whose name has to be revealed. So it's only the subject of the message, as I said, the trending post, which has to be revealed. And can an argument be made that the government does not have the power in such a situation to ask who was the originator of that message? So that's just a question I had to put out there. That's
anyone? Right there.
Sneha, I'm assuming you're talking about end-to-end encrypted platforms here.
I'm talking about everything.
Because when it comes to platforms such as Facebook, Twitter, they're already public.
No, I'm saying that today, for example, if the government wants to know what is trending, so for example, on Twitter, you'll have a hashtag or you'll have a subject identified as trending. You click on that, it'll take you to posts by individuals. So that's why Twitter has created a mechanism where the public can see who is putting up what post. But when I'm saying when the government passes such an order, saying that I want to know what is trending during public emergency, can it add on another direction saying I also want to know who put up a particular post regarding that particular subject?
But isn't that already public?
It may be public, but I'm saying when the report is going...
No, but why does it need an order to do that? Because open source intelligence, it can just keep scanning it, which is something it already does.
Maybe it's not... I'm saying a public platform today will trend a particular topic. The government does not want that to know that topic. There may be other subjects in a case of a public emergency that may not be trending, but they want to know about that subject.
So for instance, today, let's assume there's some kind of a murder that has a communal tinge. It happens in a tiny area in Delhi. It's only trending in certain parts of Delhi.
I'm saying the topic is not trending. Presume that I was just giving it as an example.
It's not in the top 25 trends, so therefore it's not visible to anyone. But why can't the government then search for hashtag murder and so or murder, whatever the person's name is?
But that's not what they want. Putting a hashtag is not their intent. The intent behind this provision, in my view, is certain keywords the government will give. I want to know on a certain subject. Yes, they can search the public forum, but obviously they don't want to just search the public forum. That will be too time consuming for them. They never have the resources. So they want to pass on that by way of an order to a private organization who will have obviously already have the wherewithal to do it because they already have systems to do it.
So how does that come into the interception category when it's already open source? It's about the resources the government has, right? It's not necessarily interception. So you're talking about an email.
I'm giving an example of trending, yes, but yes, it could be an email. It could be because this covers everything.
Right. Yeah.
Or you just disclose the message. And in a sense, 24(2) could be read to say you only need to disclose the message. But since that, I mean, in that sense, the problem is that
depending on whether you consider that the identity of the person who's sending the message is a part of the message or not.
No, but also Vakasha, I think the language is broad enough, right? Because it says message, class of message to or from any person. So you could cover a bunch of those things in the same order and say.
But I think that's restrictive, Amanna, because one, you can, if you only have to look at a class of persons and a subject in that class of persons,
Sure.
then again the argument that I will make is it's a class that you've identified, not the individual.
Sure, but I do see scope for them passing orders which are broad enough
They
to
will.
say both things, right?
So
Class of messages plus.
Yes, so I'm
to
coming from a
home.
place. I'm coming from a place where I'm saying if such an order is passed, can one of the grounds be that identification of an individual is invasion of privacy, and you do not even have the power to do it under the law? So
Okay, I think this conversation can move private now. Thank you all. I don't think we covered all that we may have wanted to, and frankly, for a bill of this scale, scope, and nature, I think we've been at this for almost 4 hours now. Is not enough. So thank you all for being here. This was fun. I think I could get used to this again, and hopefully we'll have some. Hopefully we won't be given enough reasons to do these discussions, but I'm sure we will, and hopefully we'll have these discussions in the future. I'd like to thank Google, Meta, Disney Star, ISOC for the support for the discussion, to the Center for Communications Governance at National Law University, Delhi, CIS India, and CCOA for the support. Thank you all for being there. I hope you enjoyed this discussion. In case there are some books left online, please feel free to take them. And there's also some fun candies over there from at least some childhood days sort of a thing, in case you want to pick something up. We have tea and we have snacks. Thanks everyone. Thank you. Oh, and please take smiley balls.